It is 9 o'clock. I'd like to call the Planning and Policy Committee to order here for April 10. First on the agenda is public comment for this morning. Please keep your comment to 3 minutes and name and address, please. Is there any public comment at this time?
Good morning, Sheila Detloff, Holland Township. I've got a little story to tell you. This will have relevance, so if you'll bear with me, if you're perceptive, you'll see where this is going. Starts out, I go into work early some days to get at least some of my work done ahead of time. Before work, I go on about a 5-mile walk with my dog. I live in a condo, so I walk about a quarter mile up the road and walk around in a neighborhood. About 8 months ago, while I'm walking, a golf cart with actual lights and sirens pulls up in front of me. This lady gets out and starts yelling before I can even get my headphones out of my ears. Turns out walking dogs isn't allowed before 7 a.m. according to the HOA. I informed her that first of all, I don't live there, and second of all, the streets were all public, so she couldn't really do much. She responded by threatening to call the cops and have me arrested. I just told her to do whatever she felt she had to do and walked away. She started following me in her golf cart with the lights and siren going. This continued for about 10 minutes until the cops arrived on the scene. I stopped and talked with them for a bit and explained my side of things. Took maybe 20 minutes before they came back over to explain what was going to happen. In the end, I had every right to walk my dog at any time of day or night. And as for her, the siren on her cart exceeded noise levels for any time before 8 a.m. Then to top it off, she didn't have it registered for use on public roads, and the taillights didn't work. As I looped back around, the golf cart was getting loaded onto a tow truck, and I just kind of laughed the whole way back to my condo. I think there are a couple morals to this story. If you didn't pick up on them, I'm going to tell you what they are, or at least what I see. First, don't try to enforce a rule on someone it doesn't apply to, or you may end up looking like a fool. And second, if you are going to try to assert your authority over someone you don't actually have authority over, maybe don't assume the trappings of an official organization, or you'll end up looking like the crazy lady from the HOA in her golf cart with lights and sirens and become the laughingstock of the neighborhood, or county, as it were. Thank you.
See any other public comments?
Not from me.
Not from you, Ron? Okay. Good morning.
Morning. Dan Zimmer, Port Sheldon Township. Most adults have encountered the official business penalty for private use $300 messaging on postal mailings. Most adults are able to discern that there are private instances that do not meet the official business threshold. Parading the symbolism of official business letterhead for personal beliefs or opinion is a subliminal effort to gain credibility and portray pseudo-authority. The actions of Commissioner Moss crossed a thin-veiled line, crossed the line taking a weapon into a campus, and then crossed the line advocating his personal viewpoints using the Ottawa County seal as an endorsement. Mr. Moss is a smart man, and he should know better. His actions of weapon carry and letter writing are owned by him. Silence on this matter is an acceptance of it. As a board, the time for clarity is now.
Thank you, Dan.
Good morning, Commissioners. Becky Patrick, Allendale. I'm commenting this morning on action item number 5. As you consider this item, I think it's important that you know that Commissioners Moss, Miedema, and Rohde have violated or are alleged to have violated Board Rule 3.1 on more than one occasion and in more than one way. Board Rule 3.1 is really what's at the heart of your discussion this morning. It's the rule that states that no individual commissioner can represent that they are taking action or making a decision in lieu of the board. So please consider this list. First, Former Administrator John Gibbs alleged that Commissioners Moss and Rhodey asked him to resign. If this is true, the Board of Commissioners had no knowledge of this and obviously never approved it. Number two, a judge in the lawsuit filed by former Commissioner Chris Kleinians found that, quote, the Ottawa Impact affiliated commissioners exerted pressure on MSU Extension to terminate or relocate Kleinians, end quote. Those commissioners were Commissioners Moss and Miedema. The full board never approved that action either. And third, you are all hopefully aware that Commissioner Miedema's recent actions behind the scenes to change sector assignments and term ending dates on boards and commissions, and to institute a new requirement that volunteers must consent to an extensive background check was done without the knowledge of the Board of Commissioners. This list demonstrates that these three commissioners appear to care little for Rule 3.1. Their ambiguous, official-looking letters to Grand Valley State University this week only underscore that. You may deem a policy change to be necessary, but a new policy will not stop them from finding ways to usurp the authority of the board. So what's the remedy? I recommend that you simply enforce the rule that you have. I recommend that you have the hard public discussion here today. Hold each other accountable to the highest standards. Make it clear that ambiguity is not acceptable and will not be tolerated. Consider cautioning the offending parties at the very least. Because Board Rule 3.1 is not optional. It's there to safeguard the board's authority. It's there for the protection and the benefit of the public. And it's there because state law requires it and the board to act collectively. Thank you.
Thank you, Becky. Any other public comment at this time? Seeing none, we'll move on to the approval agenda. Is there a motion to approve the agenda?
So moved.
Point of information, Mr. Chair. I just have a question. Later on in the agenda, under the Health and Human Services updates, I'm only seeing 2 committees on here today, and I didn't see an email saying that there would be some not coming, so I'm just wondering if you have information on that.
Yeah, I do. Regina lined it up and they will do quarterly reports, yeah, unless something really important comes up with their committee. So we'll kind of leave it so they'll alternate instead of have them all at once.
Okay, I would move then to add a discussion item on that topic, because I think that's something that's really important that we discuss at a committee level and not just being made by one person. I would like to have that discussion. So I'm going to make a motion to add a discussion item as number 6 under agenda and action items to discuss that.
Could you clarify what that means?
I would like to add a discussion item to discuss the amount of times we would like to see Health and Human Service updates.
Motion made, supported, discussion. Any other discussion on it? Stand by. Gotta be green. There you go.
There we go. Was this made in consultation with the staff over at Health and Human Services?
Yes.
Right.
Yes, it was. We talked to the staff and they,
With all,
they agreed with it. So that's kind of why we did it. So, yeah.
point of inquiry, like, this is something that we should discuss at a discussion item is from my perspective, and then we can actually, I'm just asking if we're willing to have further debate, discussion on this, because you might have something, but I also have more stuff I'd like to add. Just the merits of talking about it.
Point of inquiry. Who was we?
Was we,
Mhm.
me and Regina and then Gary. So. And I think it just, I mean, they were really more than good with it, weren't they, Gary? When we talked?
Absolutely. They felt that their time could be better utilized, in their offices and stuff versus sitting here for long periods of time and, virtually, when it's an every month basis, the ability to give a lot of new information from month to month is not as easy as quarterly.
Any other questions or discussion?
I don't think we have had a second on the,
Yeah, we did.
we did get it. Okay.
That Sylvia did. So.
Okay. Again, are we just simply discussing this item right now, or should we be discussing it as a discussion?
I think we have to vote on it.
We have to vote on as if we put it on the agenda for a discussion item. So,
But to her point is we've had several, all I did was make a motion. Commissioner Jartzma had a chance to speak something. Administrator Rosema just got to speak. So are we, if this committee is going to turn this discussion item down, then I'm going to just start sharing my thoughts. Because that's what you got a chance to do. Administrator Rosema got a chance to do.
I'm fine with that, yeah. No, go on.
So are we going to have a discussion right now then?
No, well, but it's number 6.
Okay.
Well, I
could
think we
take a-
should take a vote whether we're going to add it to the agenda. I mean, that's the motion, right?
Yeah.
So we
Well,
should,
well, to Allison's point, if we're going to take a vote, then I'm just going to go ahead and put my thoughts on the record because other people have. So my thoughts are that this doesn't necessarily have to, even if you want to space it out a little bit more, I would even say it bi-monthly instead of quarterly. Because there is information that's useful for the community to hear as well, like upcoming events, stuff like that. So I feel like quarterly is a bit sparse.
And to that point, at first we had a Health and Human Services Committee that got closed. Then we got added to here. Now we're getting told that it's going to be less, even less. I have a great concern while the staff might be okay with it, there is a lot of information that is really important to many of our people in our community that follow along at home, even if they don't come to these meetings. They really care about those presentations. There's a lot of feedback that's presented. There's dates that are provided for us to know about that's coming up, for the public to know about, which we will not have in a timely manner if we get rid of these monthly meetings. So,
Yeah,
okay, vote.
please call the roll.
Mr. Teeples,
No.
here, Mr. Barry,
No.
Mr. Bonema,
No.
Mrs. Rhodey,
Yes.
Mr. Zylstra,
Yes.
Mrs. Wenzel,
Yes.
Mrs. Medema,
yes.
Mr. Georgezma,
No.
Mr. Bruger,
No.
and Mr. Kyers.
No.
Motion does not pass.
I made a motion
Back
to
to the
approve the
approve of the agenda.
agenda. I make that motion. Or
That motion?
I made a motion to approve the agenda.
Okay.
Supported. And then before we proceed, I'd like to make a motion to table in the absence of Commissioner Moss. Table item 2 until the April 22 full board meeting.
Is a motion for support for that?
Or
Motion made and supported. Any discussion on that?
just point of order, no discussion on a motion to table, sir.
Okay, you're right. I'm sorry, Josh. Please call the roll.
Mr. Barry,
I'm sorry, can you please repeat the motion for me, please?
It's just a motion to table number 2 so we can discuss it more and have more input from Mr. Moss at our board meeting.
Point of inquiry. Can I ask your reason? Because typically there's a commissioner gone each time, so I'm just wondering your thought perspective.
I do apologize, but once a motion to table an item has been made, there's no debate.
Okay.
Roll call, please.
Mr. Barry,
Yes.
Mr. Bruger,
Yes.
Mr. Zylstra,
Yes.
Mr. Bonema,
Yes.
Mrs. Wenzel, Mrs. Medema,
No.
Mr. Georgezma,
Yes.
Mr. Teeples,
Yes.
Mrs. Rhodey,
No.
and Mr. Kyers.
Yes.
Motion passes.
You're good. Any other additions or deletions to the agenda? See none. All in favor of approving the agenda, say by saying aye.
Aye.
Same.
No.
Motion carried. Consent resolutions. Number 1 is approval of the minutes of March 11, 2025 Planning and Policy Committee. Some of these motions here are from previous boards from last year. So we're just kind of cleaning up like the broadband and the Executive Transition Committee meeting, so maybe some of you have more information on this than we do that were on the previous board. If so, I mean, that would be good. So,
Yeah, I wasn't on any of those boards, I don't believe, so I really don't have much information other than watching YouTube. Unfortunately, either Jacob or I on executive transition. But maybe those who aren't can speak to that.
Yeah, I know that I wasn't, like Doug said, I'd invite one of the other commissioners to respond, but essentially, these meetings took place. There's minutes for them. They need to be formalized into the record.
Correct.
In order to do that, we just need to vote to approve them. So they never had a final meeting when we switched over from last year to this year. So this is just mainly cleaning up the record, getting them formally in the record.
I'll make a motion. I'm going to do these. Can I do all four at the same time or just?
that's what I was just going to ask.
There's a
Yep.
consent resolution. So.
Okay, so a motion to approve the consent resolution for the approval of all these minutes.
1 through 4 with the minutes. Right, all in favor, somebody saying aye?
Aye.
Opposed, the same. Motion carried.
Did you get a second on that?
I did not hear.
I'll second.
I'm sorry.
Jordan?
Thank you, Jordan.
Happy to do it.
Post-secondary second.
All right. Action items, the motor vehicle permit policy update. The motion is to approve and forward to the Board of Commissioners the proposed update to the Ottawa County Parks and Recreation Commission motor vehicle permit scheduled to add a discounted rate for veteran annual permits.
So moved?
Second.
Motion made, support. Kurt, can you talk on this a little bit, please?
Good morning, Kirk Terhar, Park Planner. I'm filling in for Jason Shamlin, our director. So I don't know all of the discussion that went into this, but basically we were requested to consider providing a discount to our motor vehicle permits to enter the parks for our veterans. And the Parks Commission has thought this was a good idea and are proposing that we offer the same discount that we do to our senior citizens that are county residents. So if you don't know, our motor vehicle permits are for just select parks, our Lakeshore Parks and Riverside Park, which is our largest boat launch facility, only from Memorial Day weekend through Labor Day. So you need a vehicle permit. You don't need a permit to bike in or walk in, but you need one to park there. So this would provide the discount for county veterans, just like the seniors.
Yes. Any questions for Kurt?
What's the dollar amount of that discount?
Let's see, the regular annual permit is $25. So this would be for seniors and veterans down to $9.
Nelson?
I just have a question, and I don't know if it's for Kurt or if it's for the board, but my wondering is, what would the board's thoughts, and I guess I would like to hear Kurt as well, what would the thoughts be on extending it to those, to include those on active duty?
We haven't talked about that, have we, Kurt?
Yeah, I wasn't part of those discussions. That certainly
was,
could be
we did
considered,
that.
but okay.
We can bring that back to the Parks Board. I have no problem with that.
If that's the case, is that something then that you'd want to wait to do this item on, or would it just be bringing it back before us again
But-
to see if they would be
Yeah,
interested in doing that?
Ron, do you have something to say? I thought you were gonna, no?
Which one?
You.
No.
Oh, okay.
No, I was just
Thought you-
sitting up
gave me
straight.
I mean,
the
it probably
concept.
would be good to act because people are thinking
the
about
permits
buying
will be
their
coming up.
permits at this point in the next couple of months. So,
Is there any reason that we can't just add that on as a board level?
Don't
Like,
see no
why
problem with
wouldn't-
that. I don't see no problem with that.
So I'm gonna make a,
I think we have the authority to do so.
To pass the parks, does it have to approve through the parks first?
Parks is just
I don't
a
think so.
recommendation.
Yeah.
Yeah.
so I would just add make a motion then to add, to include active veterans, I'm sorry, those on active duty.
With the veterans, yeah.
Do we have any number of how many people that would add to this? I just don't want to throw off any parks projections. I can't imagine it's all that high.
We talked about it
No
before. It
idea.
was not a huge number, Jordan.
Okay. I have no problem with it.
Kendra seconded it. Oh, everybody heard that. But yeah. We've got the quiet seconds going on today.
Green light.
So
on.
we have a
just to clarify, so to get this passed, they just go through the normal process that they would to get a parks pass? there anything
Yeah,
special
it
they
has,
need to
this
do?
would have to be on, they'd have to do it online because the fee machines that we have in the parks aren't capable of some of these more complex discounts. But yeah, that would be just the same as anybody else. Go online and get your permit.
And if our veteran is already a senior citizen, the price is still the same?
I believe so, yes.
Yes, we talked about that. Yeah.
Okay.
No double down, and they said. so.
Okay.
It's worth a try, right, Jacob?
Hey, you know what? We're down to $9. That's pretty affordable. So
There you go.
Yeah,
It's pretty cheap for what we get in parks.
It is.
Absolutely,
a
absolutely.
lot of value.
So we have a motion to amend the motion. We have support.
Support.
Kendra supported it, yeah.
We, Kendra did. We have a roll call on the amendment.
Mr. Bonema,
Yes.
Mr. Georgezma,
Yes.
Mr. Berger, sorry.
We call them.
Yes.
Go ahead.
Yeah, it's, I've been called worse. Yeah, yes.
Mrs. Medema,
Yes.
Mrs. Wenzel,
Yes.
Mr. Barry,
Yes.
Mrs. Rhodey,
Yes.
Mr. Zylstra,
Yes.
Mr. Teeples,
Yes.
and Mr. Kyers.
Yes.
Amended motion passes.
Thank you.
Any other discussion on that? So could you please call the roll on the motion for the vehicle permit policy, please?
Mr. Teeples,
Yes.
Mrs. Medema,
Yes.
Mrs. Wenzel,
Yes.
Mr. Barry,
Yes.
Mr. Zylstra,
Yes.
Mr. Berger,
Yes.
Mr. Bonema,
Yes.
Mrs. Rhodey, Mr. Georgezma,
Yes.
and Mr. Kyers.
Yes,
And the motion passes.
thank you. Move on to discussion. Number 3, the discussion legal ramifications of denying ramified contracts.
I guess I can
You can start with that, please.
I can give you the elementary version of ratification, but you gotta understand a little bit of the history. Years ago, if we had a contract, we had the page that we stapled to those contracts, and they all ended up on the in front of the Board of Commissioners, and they took appropriate action. And there was also an emergency process that if, as a department head, we missed that opportunity, we'd staple another form on the front of that contract that said emergency contract on it. So that meant that that was one of the first ones that the board took up at their next meeting. You know, as on-base was developed, there was a process with an on-base that Corporation Counsel, Fiscal Services, and this position could review those contracts and make some decisions about them based on the fact that ratification then became something within county policy. So again, that was, as I looked at it, that was primarily for the idea of a checks and balances and creating oversight. So the board would eventually get to see those contracts in a different form than major discussion because the threshold was put at $70,000. You know, it's been a good process. It moves stuff along. It takes care of situations where a product is even delivered to the county or a service is allowed to move forward, so we aren't constantly waiting for a Board of Commissioners meeting to do some of that approval. So again, the major concern with discussion on contracts, or not discussion, but the ability to pull them out of the packet and possibly deter us from moving forward with a signed contract creates a little bit of a liability, or significant in some cases, because the products may have been delivered to the county, the services may be in process, or they could be completed, and there's an obligation for us to take care of those contracts. And I don't have an idea why the 70,000 was the threshold that was approved at the time. I assume because, we do a lot of contract review, and there's a lot of services that require the contract process. So, unless you have some legal questions that maybe, Ron can address, but other than that, it to me appears to be a good process. It, I feel comfortable with it, with the fact that I understand it better today than I did in January. And it does afford legal to look at, detailed contract information. It allows Karen from a fiscal point of view to look at it and have a good understanding that the funds are there, and we can easily move forward with this project. So there's communications also in the process, and probably communications more from me now because, I'm trying to get to understand some of these processes as well. But again, I think it creates good oversight for the county board in our day-to-day operational basis.
Thank you, Gary. Some of the contracts do have it in there already, though. If they're not approved through ratification, then they are in void, right? But some of them do not, correct?
Right,
So
that's
they're
correct.
not all that way.
Right.
Okay. That was the concern we had, correct? Yeah. Okay. Any other comments?
I got
Jeff?
just a question. How many times are those contracts reviewed before they get to us? Or what's the process on the backside? I honestly don't know that answer.
Well, they're reviewed by corporate counsel, they're reviewed by fiscal, and then I look at them. It's the third leg of the stool that they sit on.
Okay, okay.
Is
Thanks.
is there a policy that you're referencing, Mr. DeRosma, regarding this?
Yes,
Okay, which policy? Because I don't think I didn't see it on here, but maybe I missed it.
I'll get you that.
Allison, are you referring to the $70,000 policy or?
Well, I just
I
want to
don't- I don't
know,
know.
like,
What it is either.
I just want to
The
know,
resolution
with
that
what we're
was-
discussing on, right, any relevant policy that relates to this discussion.
There's a contracting authorization and form policy that talks about the $70,000 and the processes that we go through. There's a resolution that the county board did as it relates to the process.
Yeah, I'm trying to find it on our portal, like under the fiscal services policies. And if it's on there, I'd really like to know which policies so that we can have a better intellectual conversation from our standpoint.
Okay, I'll get you the location of it, where it is.
Like where the policy is located?
Yeah,
So if you go to legal policies, you'll see it under the contracting policy.
under the legal one.
So go all the way down to legal policies, which is the last one.
Yep.
Contracting policy,
The first one listed.
the first one, yeah.
Yeah, okay. Thank you, Commissioner Zastra.
And it was last reviewed on October 28, 2024.
Yeah, I know that legal had gone through it. Since we're having a discussion on it, I just wanted to be able to look through it.
The original policy was developed in March of 2020.
Any more discussions or comments on the ratification? Ron?
Yeah, I raised a question just basically as a new bystander initially. Like what happens if the board doesn't approve a contract? Do the vendors know that even though they have a signed contract, that it may or may not be actually approved by the county? And My question is, do the vendors sometimes rely on those signed contracts prior to board approval and act and deliver services or provide goods? And do they understand they're doing that at their risk? I don't know the answers to that question, those questions. I didn't get answers when I raised the question, so I just like would want to be clear on that.
I think our draft template has specific section on it. I think that's probably what you're going to say, right?
Go ahead.
Yeah, no, I mean, it has specific language addressing if the board does not approve it, then finished services, get paid for the service that you finish, right? So anybody, a vendor who is contracting with us, it's spelled out in the contract itself.
So they're paid to the extent they relied on that until the point of board.
Yeah, I
denial?
don't have a draft contract in front of me, but I can pull one up real quick in section 3.
I don't know if that's true, if that actually happens in practice.
I'm just reading the contract. I'm not a lawyer, John, so.
That, I don't know. I didn't notice that when I mean, I'm getting a lot of contracts. I'm the last step of that leg.
What time of, before it comes to the committee or the board, John, when are you being presented to sign? Because I'm just wondering, are you able to sign after it goes through us? What is the time difference?
No, no, I'm the last leg before the board. So it's gone through legal. It's when I see the contracts, it's already been signed by everybody that needs to sign it. It could be Justin Roebuck, it could be the administrator. It's signed all the way through. And then there's my signature, and I get it multiple contracts a week, right?
Right.
Some of which, frankly, I don't know why we even get, like CMH. I mean, it's already gone through their board. Why are we getting it? I don't understand that at all. But still, it comes to me, and it could be the first day of the month, or it could be later in the month, right? They're coming all the time. And so my concern is on this, is these have already been, like they've talked about, contracts out the door. And if they don't have that disclaimer language that you're talking about, Doug, where does that put us at risk? Because they've gone out the door and in a liability exposure. That's my concern with these things.
Right. Yeah, I'm just pulling up the Ottawa food contract that we talked about last time, and section 3 says the contractor understands and agrees that if the board refuses to ratify this contract after it is signed by both parties, this contract shall be null and void, and all obligations to provide services and otherwise perform under this contract shall cease, except the county agrees to compensate the contractor for services and/or work performed. So, I mean, whether the vendor reads that or not, we can't
That's
sit
not my
behind over their
concern.
shoulder and make sure, hey, did you read section 3? Maybe we can put a little star behind it and say, look, this contract is in post ratification, and just be aware that, there is a very minimal chance that it won't be, approved. I've been here since 2021. I don't think there's been a contract that we've, not approved on post ratification.
Not that I remember.
So, I mean, it is a minimal risk to a vendor.
And it does have a whole section on here that talks about the pre-approval of the Board of Commissioners as well.
Sylvia had a comment over here
Well,
a minute ago.
yeah,
I heard you. Yeah.
yeah, I just think there's a couple things
So
that.
this is,
Sorry, I just think there's a couple things that we should look at, because this contracting policy is one thing that we've mulled over, over the past couple of years too, because there just are some complicated things here, obviously. So, maybe we want to take another look at the contract or the policy itself even, do we need to change anything on this? 70,000 is really high. To have things just ship out the door without a closer look from the board. So that's one question I would have is, do we want to keep it at 70,000? That's something that we've thought about before. I'm just going to put my questions on the table a minute.
Sure.
Okay, Doug. So there's that. Another thing would be is, just with the process involved in these contracts, it really does end up being a lengthy process. So I hear you on that, in that it's gone through multiple checks and balances before it hits you, and all of those things take time. And so But I do wonder if the board should see it sooner rather than later. And if that's not a possibility, I mean, the problem is we're bunching all of this stuff once a month, and then it goes to finance, and then it goes to the full board. So that adds so much time. So, it almost makes me wonder, like, should we be approving these like bi-monthly instead of monthly? That would be a question. I know that we are only having board meetings once a month, and that's a little problematic when it comes to this. But if we were approving these, bi-monthly instead of just monthly, that would help things a lot. Because again, just these timeframes are just really difficult. So anyways, I think those are my two biggest things. And I agree with the language. I think the language has to be in every contract and, highlighted if at all possible.
Commissioner Delson.
Yeah, no, I don't disagree with you, Commissioner Rhodey. I mean, it was up in 2024, and I don't know if there were any red flags at that time. And, maybe we didn't see them because of, the end of the year. Would have been cool to see them then, but if we need to take a look at that now, I have no problem. I think 70,000, we can discuss whether that's the right number. When we first saw this in March of 2021, there really wasn't a discussion of the amount, and, we can easily have that discussion, so.
I don't know the history of why that amount is there. I don't know if we could look back. Karen, you have any idea why we do the 70? No? Okay. We can look into that, I agree. Yeah, that'd be interesting to know.
And I think there were some reasons,
I do.
certain things that came through that just maybe felt more routine with that number, but again, it's high. And if it needs to be that high, maybe we need more frequent review. So.
I mean, it's one of, as you say that, I'm thinking, we could, and if we revise that policy, we could make it that we approve those kind of contracts bi-monthly at finance and at the board meeting and put that, and then we could cover that issue. I mean, my biggest concern is I don't want to expose the county to liability because we've already signed contracts, right? So if we get to that bi-monthly process, I think a lot of that will go away, especially if we add the disclaimer language as a standard practice as well.
My question would be is, when you're talking about bi-monthly, I'm assuming at the moment you're thinking one at finance and one at the board level, but we don't make a final decision at our finance committee.
Yeah, we'd have to pass a motion to do that. When on this issue.
Could we delegate that authority to the finance committee?
What's that?
Gordon?
Delegate that authority to the finance committee to be able to approve contracts?
We've got an attorney here to answer that question.
And another interesting thing with that is we actually have the full board here. And so, so one of the things actually that, I'm going to speak for you, Allison. Allison had noticed on, in looking at our agendas, and she's right on this, is that the language of our motions is that we're approving. It does say that we're approving and moving on to the full board, I think, though, in some of them, but actually it doesn't. It's just saying approve. So we're actually voting on things with final language with a full board sitting here. And so that, even that language, I think we need to take a look at, because what if we make a decision here and then we go to the full board and within those 2 weeks, we've changed our mind and we make a different decision? Have we legally voted on something at this level with a full board and then we voted differently in 2 weeks? So we might want to take a look at some of the language on our agendas. But anyways, so it's kind of related to that other matter too, in that, maybe there would be a way to, we're all here,
Correct.
we could vote.
That's why we do is meeting the whole, so we would
Right.
do that, correct?
Yeah.
So, Commissioner Ray, I don't have all the agendas in front of me, but the 3 items, or at least the items that we have approving forward.
Yes.
I mean, I understand what you're saying, but I think that we've been consistent.
I just think that we need to watch that and be careful, because when you go to the finance agenda, like item number 2, it says to approve the general claims and there's no and forward on it. So just a legal thing that we maybe just need to consider. And we've done that over the past 2 years too. So I mean, it's been consistent going back years that it's
Done
been
what?
that way.
We've done what?
Had this same language. But for instance, last year, it would have been fine because we didn't have the full board on our committees, but 2 years ago we did. So when we have the full board sitting here, we need to be careful of the language that's on our agendas.
I'll take it, yeah.
Mr. Bruder.
With Ron here, wonder if we could use your expertise a little bit. I guess the question is, well, one of two. Can we as a finance committee approve contracts at our finance committee meetings? That'd be part one. And could we change language in our contracts to maybe show that? Part two, I'm just looking down the road. If the finance committee were not a committee of the whole, would that change our ability to do that? So those would be my two. Sorry to put you on the spot.
No, it's okay. I'll address both those, and I have a third part that I want to address as well. The board can certainly give to the finance committee contracting authority. So if you are clear on delegating that authority to the finance committee, that is a legitimate exercise by you of your authority, and the finance committee can rely on that. And that doesn't matter whether it's, whether the finance committee is a committee of the whole or not. The one thing I would caution you about is even when you have a committee of the whole, don't rely on the fact that, well, we're all here, so this is like board approval. No, it's not. It's a meeting that's advertised under the Open Meetings Act as a committee meeting, and you have to stay within the parameters of the committee's authority at that point.
Makes sense.
Can I
Mr.
ask,
Meadler.
can you possibly share with us, Ron, where you got the information that we can give a committee the authority to give approval for contracts? And you don't have to do it right this moment, but I would really like to see where that's coming from, because I'm trying to think of other instances where a full board, and when you don't have a quorum, how that would take place.
Well, you would have to, the authority that I'm using is basically general municipal, general corporate law, and even public or private. The board has the contracting authority, the county board. But the county board can say, as I was afraid it had done, that staff could sign and it could be a binding contract. That would be appropriate, it'd be legal. But in fact, we've got limitations on that, so that that vendors should not rely on that unless and until there's a board approval. But the board, as the contracting authority for the county, can delegate that to a committee and put safeguards on it saying, you may commit us, we will agree that the county will be bound by a contract if it's approved in this way, even though it doesn't come to us. If the county adopts a policy saying that, the county's exercising, the county board is exercising the contracting authority then, and saying not every contract has to come to us. And that those contracts approved under the county board approved policy would then be binding on the county. Am I addressing your question? I think I am.
Yeah, but I'm going to be pondering it for a little while.
Yep.
Thanks.
You want to see something in writing, and
I
I'm
do.
telling you general.
I do want to see something in writing. Yeah, I do.
More discussion. Well, good discussion. Thank you. Let's move on to number 4, discussion on the Campbell plant. Gary, we sent a request out, correct?
Right, we've talked to GCSI. The Public Service Commission has indicated that they'll give us a response this week. So I talked to Bob DeVries again the other day, and he said he would contact them next week to see where the letter is, so.
So we're kind of waiting on that for a response, what we can
And
other do.
we can anticipate what the response is going to be.
Commissioner.
So the anticipation is that they're going to hold firm to keeping the closure going, correct? And that they're not going to step in.
I suspect that's what, is
Okay.
going to be the answer.
May I share with the board some of I've done a little bit of digging, just a little bit.
Sure, go ahead.
So in reviewing our resolution and then in reviewing the Michigan Constitution, the line that we put in our own resolution, the Michigan Constitution does give authority to our board to enter or to intervene in any action or certificate proceeding involving the services, charges, or rates of any privately owned public utility furnishing services or commodities to ratepayers within the county, and that's from Article 7, Section 15 of the Michigan Constitution. And then there is one, not exactly the same, but there is one case law search that I was able to find on this. And while it's not exactly the legal case on point, there is a case that was filed last year in the Michigan Court of Claims, which I can forward on to you guys, by 75 counties of 83 against the Michigan Public Service Commission regarding local government control to regulate green energy projects. And while this one's different, I actually feel like we are actually in a different, like that one I actually felt was maybe even outside of the bounds. Like that would have to be tested, right? And it is, I haven't had a chance to read through all 75 whatever pages yet. And so I'm just saying that from my perspective, I think we do have the authority to enter into a legal pursuit if we so choose. I think it's really important to our community that we take this very seriously. It's not something that we just enter in frivolously. I think we have done our due diligence. I think we're waiting to hear back. I think we know what we're going to hear, as you shared. And if that's the case, I think we really need to consider entering into a legal suit at our next board meeting. I think we need to have something prepared for our board to vote on. That's what I'm going to currently share.
Any other comments? You know, me and Jim attended the stakeholders meeting with consumers, and they made it very clear that they are concerned, as we have the same concerns as we do. If I'm reading this wrong, Jim, let me know. So they were confident that the grid would not be jeopardized by what they're doing here, and financially it would make them further ahead by not burning coal compared to other natural resources.
Yeah, the natural gas plant they acquired in Covert produces at a much lower cost per kilowatt than what the coal does. And I think that's one of the drivers on their wanting to go along with that transition. Also yesterday, I had a conversation with folks at Lakeshore Advantage just to get a feel for what was the business community's thoughts on all this. And they're comfortable with the direction that consumers wants to take on this. They are relying a lot on the long-term reputation that consumers has had as a good neighbor in the community. They pointed out that consumers has invested millions of dollars.
You pull your mic right up to your face. There you go. I know. Okay.
They cited the millions of dollars that consumers has invested in Ottawa County, not just in the power plant, but with substations and starting to bury power lines and things like that. And they're not abandoning the county. There'll be a future use for the Campbell plant as well. But it was kind of an interesting conversation that Lakeshore Advantage, which is probably a preeminent economic development organization in Ottawa, Allegan County, we're comfortable with it.
Yes, Mr. Rhodey.
I have a question, so ignore me if you don't want to answer, but Jordan, I think I saw you make note of the executive orders in regards to this. Do you have any more information on how that might impact?
You know, I haven't studied the executive orders in depth. I do know yesterday on Fox Business, they were talking about it, and they actually featured the Campbell plant briefly. And I believe Fox Business reached out to consumers for a comment, and they said that their plan was to review the executive orders and make sure that their closure plan was still compliant. So again, I would probably echo what Gary said. I don't have my hopes up. I mean, we're weeks away from their closure. But yeah, I think the executive order does change the calculation a bit. As far as what this board should do, I think we can explore any options, but I think we have to have a very, very high bar before we enter into legal proceedings, just given the sheer volume of legal actions that this board and this county has been involved with over the last couple of years. So, yeah, I think we did the right thing by bringing it back to the MPSC. I don't know if there's anything else that needs to be done at this point, but we can have that conversation. Commissioner Meadman.
I would just share, I appreciate your comments and some others that have shared here, that I just don't want our board to forget the information that has been presented to us, the concerns that we had, and why we actually drafted a resolution. I don't think those concerns have just all of a sudden disappeared by a couple conversations, and I appreciate your further conversations that both of you have had. But I don't think those concerns have faded away into the background. And we are at a time where the time is very fastly quick. It's quickening, right? To where they say they're going to close. And the reason why we have a legal system is for something such as this to come alongside of when we have something that's as important as this to our community. It is something we really need to take seriously. And when the Constitution was written, it was written for situations such as this, for us to have these serious conversations. And I think that we have done our due diligence up to this point to try to avoid any form of legalities. But I do think this is an area that we should step forward into, especially if their decision doesn't change before their next board meeting.
I feel very much that when we passed the resolution, I guess this is for me, I felt like we did our job. And I hate to speak in past tense because that tells you where I'm heading. But the point of the resolution to petition the MMPC to take a second look to see if anything had changed since their initial approval of that was like asking a doctor for a second opinion. And if they've decided that they're not going to take action on it or change, or their opinion is still solid based on the information they have, professionals in the field, I'm not interested in challenging them. I appreciate that we can, but for me, this would definitely fall into the state level or federal level issue at this point, that we as a county have done our due diligence. For me, that's where I feel.
I guess I have one other thought, and that is, I think that we should look more into the executive orders and what's happening there, what exactly those are, and maybe legal could help us with that. And then maybe as a county, we could be communicating with the federal level and ask them to take a look at our specific situation, and does it rise to the level where the federal level could intervene on our behalf? Maybe we could do that as like an intermediate action. And, then if that's not going to bring us some resolution, then maybe we take a look at something like Allison is proposing. Or maybe we explore both at the same time, but don't necessarily, begin a lawsuit. But I think that we could advocate for our community with the federal level, especially if there's some executive orders happening on these issues, and maybe they'll step in and they'll help us.
I actually agree. I think, was it last meeting that we had when we were talking about the NACO conference, and we talked, Commissioner Bonema talked about this too, the Office of Intragovernmental Affairs within the Trump administration. That could be a useful resource to us that maybe we want to put it on their radar if they don't already know. But I do think it's probably more appropriately looked at, or legal action would be more appropriately taken by the administration rather than Ottawa County, given that the Campbell plant doesn't just produce energy for Ottawa County, but the whole state, so.
And I would echo that. I would enjoy exploring both options due to the time that we have left before it implements closure. I think it's really important to come with options before our board here to consider. And we do still have local control, and we have the state constitution. And so I don't want us to just say like the federal government's just going to come and help us out. I would love for that to be the case. But I don't want us to just act like we don't have any form of control when we have been elected to serve the people here in Ottawa County. That we have the power to do so. The Constitution tells us so. So I don't want it just to be a scapegoat to send it to the federal level.
Commissioner Benema.
Yeah, from my perspective, I have heard from some of my business owners in my district, and they're some of the
Up further? I can't get no further up.
Speak up.
Oh, speak up. All right, we will call the meeting back to order. Discussion, we are on discussion of the Campbell plant. Commissioner Bruger. Yes. Okay.
Testing. Oh, there we go. Hey, hi, I'm sorry, everyone. I was just, before we took our break, I was gonna throw out the idea that maybe a couple people get together and draft a resolution to petition who's our federal, sorry, Jordan,
The Office of Intergovernmental Affairs.
there you go.
And Nico? Yes.
To look into this and then bring that resolution to the board, next board meeting, and we
With an
could, we
update?
could vote on it.
Yeah.
Yeah. I'm not making a motion to do that right now. I don't know if we do that out of a discussion item, but if anybody wants to work on that, I think that'd be the next step to bring it to the full board. I worked on the last one that we did for the state of Michigan, so I'll tap out. Somebody else can pick that gauntlet up and run. Jacob and I worked on that together, so.
Any more discussion? So I'm thinking, I'm hearing, go ahead. I'm sorry.
I just want to point out that the electricity generated at Campbell isn't necessarily the electricity that generates electricity that turns on the lights in Grand Haven or New Zealand or anything like that. It goes into a grid. And I just looked this up there. In the MISO grid, there are nearly 3,000 generating units for power plants across their vast footprint. And there are hubs within that, within the whole grant, in the whole grid. But Campbell is just a small thing. With or without Campbell, the grid may still have some problems. But I think Campbell is a small player in a network as big as that. But I'm also the first to admit I claim no special expertise in this whole area. I think that's why we've got a Public Service Commission that should be reviewing these things. And now we've got the overlay of some executive orders, and I would expect Consumers probably has lots of attorneys taking a look at that, and I would expect they'll comply with legal orders. So I'm not so sure that this is a county issue. If this was a threat to the grid, I guess I would like to know why we aren't hearing from other people outside of Ottawa County about the risk, because if the Campbell caused a risk to the grid, it would affect a lot more people than just people in Ottawa County.
Thank you.
I got one more. Bill, I just,
Mr. Rhodium.
sorry, go ahead.
Your second, Josh.
It's all right, go for it.
I find that interesting, Commissioner Berry, because I think in the past you have brought us information from, is it MISO, that it actually is a problem if this plant goes down, and that they had serious concerns about losing this plant. So I don't know. I think there are different people saying different things.
What I read, they were concerned about the pace of closure of coal plants. I didn't hear that. I didn't see that they were talking about Campbell specifically.
Okay.
I was going to say, you brought up an interesting potential legal argument on the Michigan, whatever the constitution that gives us the authority to, hold a municipal or a power plant liable if, or force them to stay open, let's say in this case. I'm just wondering if, because MISO is such an integrated grid, one, can consumers claim, if this were to pursue legal action, could they claim that that power isn't actually all distributed in the county and therefore the law doesn't apply? And or could we then, as a recipient of power coming from another county or part of the MISO grid, enter a suit against some other company in Detroit, for example? We could debate that all day. I think for me, the conclusion is the best course of action is not the legal course at this time, but to go with a petition. to the federal government, which, by the way, Jim, I'm on the same page with you. I'm encouraging us to write that. I won't be voting in favor of it, but I think that's the next step, is to vote as a board and speak as a board.
Mr. Chair?
Commissioner Beaman.
I'm wondering, so maybe when there's more than one county that's affected by the grid, perhaps they would actually be able to join into a legal pursuit.
Yeah, right.
So it's not that you wouldn't have the legal authority. It's just that maybe other counties actually would have the opportunity to join in.
Yeah, all kinds of theories. Yeah, yeah.
Mhm.
Very, very legit.
Okay, I think what I'm hearing is what we're doing, we're gonna contact NACO, and we are going to have an update from hopefully from our lobbyist at the next board meeting.
Is there anyone else here that has interest in pursuing the legal, at least for our understanding, for something to be drawn up to take a vote on before our next board meeting?
I personally would like to see, if our legal counsel could look into it a little bit more. I would love to know, like, what would our legal standing be in a case like that? I'm with you, Allison, in that we're running out of time. This plant is looking at closing quickly. And so it could be we'll hit a dead end with the executive orders, and then where are we? So I wouldn't mind exploring both at the same time.
I am open to hearing. I think we need to also understand what the potential cost of that is going to be. A legal, issues like this aren't cheap typically. But I mean, and the other part of it is the courts are not fast.
Right.
So,
True.
we're weeks out. The fastest option might be going right to the Office of Intergovernmental Affairs through the administration. So yeah, I hear what you're saying, but I don't know one way or the other. Unless a judge were to put a stop order on their closure, it's not going to be heard for months. So,
But that's a fair point, right? Like it could slow down it could delay the closure because of an active lawsuit.
And
I suppose I'm not a lawyer. I couldn't speak to that
So it'd be
specifically.
great to find out.
Gary's raising his
Do you have a comment, Gary?
finger and
Yeah,
Ron's smiling.
I was at a meeting last week or the week before. I think a few of you folks were there. We were told that in order for Campbell to stay open, they would have had to order their coal supply 4 months ago. So, the concern is, telling them not to shut down. It doesn't even appear that they're able to get the coal that they needed to operate right now for a long period of time.
well, it certainly sounds like there could be a pause then, but at least if they stop disassembling the plant, it wouldn't be as hard to turn it back on. But I also like the possibility when you look at the other lawsuit, Allison, in regards to the other thing,
Mhm.
the fact that there were 73 counties that came together. So if this plant closure may potentially affect more than Ottawa, to your point, bearing the cost of legal action could actually be spread around with other counties who would also be affected. So that could be another consideration.
My understanding of that lawsuit is more of a zoning issue than anything else, that there's a state agency that has the authority to place these solar farms or whatever, wherever they want to put them. And it supersedes local authority. And I think that's an issue that's centered primarily on how local government has the authority over zoning.
That's me taking of it too. Commissioner Salister.
So just for clarification, I'm not in favor of a lawsuit, but is the idea that you would sue MPSC or that you'd sue Consumers Power?
That would be what I'd want to refer to our lovely legal department for.
Well, if we.
Yeah, I just
reduce-
want some clarification what we're thinking about doing. Like I said, I'm not in favor of doing either of those two things, but
Yeah, the state constitutional provision arguably gives us standing to try and do something, to intervene in the proceeding or,
MPSC or Consumers Energy?
with regard to the the utility.
Okay. The Consumers Energy.
Correct.
Okay, not
Yeah.
MPSC.
Any county has the authority to enter or intervene in any action or certificate proceeding involving the services, charges, or rates of a privately owned public utility.
Okay, so we would be suing Consumers Power.
So presumably, but the proceeding involved MPSC as well, so.
So we'd be suing both of them.
Could, if we would sue somebody, we would sue both. The more defendants you get, the better off you are. The problem is, we'd have to prove, number one, that the utility provides commodities to ratepayers within our county, that we have some special standing and I'm not sure that that's true, that we're not, even though the plant is located here, are we getting services from that plant any more than anybody else spread throughout the state? And obviously, we would be taking on the experts of Consumers and the MPSC who have determined full speed ahead on the closure.
So the grounds would be that they made a mistake at some point.
And none of us, including me, are going to be able to make that argument effectively. We would need our own experts, a whole bank of experts.
Somebody would have to make the argument that MPSC and Consumers Energy made a mistake in 2022.
Agreed.
Okay.
And that we are all at risk because of that.
Okay.
Well, I wouldn't say necessarily that we're claiming they made a mistake. I mean.
Well, that would be the grounds for a lawsuit, right?
No,
Ron?
new information came out in
Well,
this.
but that's exactly what
report.
Ron is saying, is that the grounds for a lawsuit would be that MPSC and Consumers Energy made a mistake in 2022.
It would
Made a
be-
mistake or reached the wrong conclusion, or it's the wrong conclusion now, whichever.
Sure. When new information came to light in December of 2024, this is 5 months ago, well after they made the decision, that was when this NERC report came out saying, oh no, our grid actually is at risk for blackouts and brownouts. That would be the crux of the argument to me. It's not saying that they came to the wrong conclusion 2 years ago. 2 years ago, it was probably a very fiscally and reliably sound decision that they made, but new information came to light. So that's how I see it.
Mr. Teeples, Commissioner Teeples.
I would not be in favor of any type of lawsuit, but we can add this to the agenda in 2 weeks, waiting for the letter from Michigan Public Service Commission, so we have something that we can look at as a factual basis. But then, like Josh suggested, someone draft a draft resolution, moving it on to NACO in that Intergovernmental Affairs Committee, if you want. We can vote on that as a suggestion.
So just to clarify, the letter would go to NACO or to IGA? Because obviously those two different things.
IGA was the original intention.
The IGA is part of the White House, right?
Yes,
So
it's a
NACO is obviously not part of the White House.
Correct. Yeah, it would not go through NACO.
Okay.
I'm good with that, with the consensus we're coming up here. So that's kind of what we'll do. We'll move it forward to.
So if in the next week, because the agenda for the board meeting will go out hopefully next Thursday or so, if someone wants to get something to me, we'll put it on the agenda. Okay?
Thanks, Jen.
I think that's something that probably should be decided, who's going to actually work on that before. I don't know, I could be wrong, but who wants to-
Volunteers?
If I were,
I can try.
I would be willing to possibly work with Commissioner Georgezma or anyone else that wants to. I don't know if
Very good.
Jacob's up for another round or not.
Another round? I'm also against getting into litigation. However, I think we need to do what we can as county commissioners to advocate that everyone take a look at this before we go too much further. So I think, common sense says that the ship sailed, but at the same time, it's our job as elected officials to be a voice. And when my constituents reach out and say, be this voice because we're concerned, then I want to continue to fulfill my duty to them by being that voice. So, yeah.
I think you just signed up for round 2 there.
It sounded like. Honestly, I don't think this is a complex resolution. I think we can probably do something to to ask NACO and ask the Office of Intergovernmental Affairs to
Yes.
take a look at it. And I would hope we get bipartisan support for that. So
For which?
Great.
Sorry.
for them to take a look at it. I mean, we're advocating for them to take a look at it. I mean, I'm
I guess I'm.
Not to get into a lawsuit,
When you
but-
say it, what does it refer to?
the Office of
No, when you say
Intergovernmental.
take a look at it, what
Oh,
does it refer to?
Shutting down the Campbell plant and what effect this would have on our constituents' rates
grid.
and grid stability.
So you're going to ask IGA to weigh in on that?
Well, to take a look at it.
Okay.
So
I don't know that we have much more jurisdiction as county commissioners.
Okay. All I'm saying, you're not, I mean, I'm not guaranteeing you're going to get bipartisan buy-in on that because I'm the only Democrat and I would not be in favor of that, but it's all right.
I think he was referring to bipartisan support at the national level. Is that what you were?
Possibly.
Yeah, there you go.
So whoever's going to draft this, just please keep in mind that we would hope to get the agenda published Thursday, but certainly Friday, all right? So keep me posted on how you're doing. Because you know how I feel about changing agendas if we don't have to. So, because I think public has the right to know what's happening. So just keep me posted on how you're progressing, okay? So we know when to publish that agenda.
Very good. Thanks.
All right.
All right, we'll move on to discussion item number 5. Discussion commissioner usage of the county logo. We've had a lot of input from a lot of the people in the county about how Commissioner Moss used the logo at GVSU. And so I think it should be a discussion item here. So that's kind of where we're at. Would you like to take this off, Gary, about bylaws? Or am I taking you? Yeah. Teresa?
I'll start with it if you want.
Okay.
I think the community has an absolute right to understand when we as commissioners speak, who we speak for. And I think that the original letter that went out by Commissioner Moss and now Commissioner Miedema raises confusion in the community that we need to avoid. I also believe in our board rule 3.1 that says that our authority to act is collective, not individual. And there's other policies in the county, particularly dealing with employees, that would have prohibited the use of the county logo for a personal reason. Last Friday, Josh and I met with Commissioner Moss to discuss this. And I pointed out that the logo, in my mind, is a intellectual property asset of the county. And it'd be no different than an automobile that's licensed to the county, and that none of us have the authority to just go take the automobile, let alone use the intellectual property asset, the logo, without authorization. And I don't want to speak for him, but I think we came to a really good understanding about that, with the idea of trying to avoid public confusion. What we discussed as an option, and I think Commissioner Miedema's letter was a step in that right direction, is what can we do if, well, the first step is, should commissioners be able to use the logo at all, even if they identify themselves more clearly as to who they speak for or on behalf of? And if so, what can we do to help the market, right? Help the community understand, to avoid confusion. What we discussed with Mr. Moss was the use of the county logo by a commissioner, provided that it's clear that the commissioner is representing his own views and not the views of the board. And so we talked about the idea of having letterhead that we commissioners could use that would say, for an example, from the desk of, have a disclaimer that the representations made represent individual views and not those of the community. and also identify the district in the signature line, which is what you did. And we talked about those ideas. Again, to avoid confusion. This issue has been blowing up my emails and voice messages. And I can see legitimately why. And so I think that we should figure out how we feel about the use of the logo by county commissioners. I can tell you that we just got back from the MAC conference. I talked to a number of commissioners in the state who just couldn't believe that a county commissioner could use the county logo, period. I didn't find anybody that supported the idea, but it doesn't mean we can't, right? As long as we are clear to the public who we represent when we use it. So the first question I think we should be asking is it okay for a commissioner to use the county logo? And if so, under what conditions that you should be? And then if there's conditions, then okay, then, you know, how do we put safeguards in there so that there's no confusion in the community? That's how I'm teeing it up.
Yeah, and oh, sorry, is that okay? Yeah, John and I did have a very good conversation with Joe, and it was interesting to see and John, I don't know if you know, but Sylvia wrote a letter as well. Okay. Which I read. I didn't read the whole letter, but the thing that I was looking for was the identification that it was Sylvia and her district. And to see the evolution from Joe's letter to Allison's letter to Sylvia's letter, it became, with each step or each iteration, it was more and more clear that this was an individual commissioner who's sharing their views as on behalf of the president or whoever it is. So I appreciated the transition there. And I think, yes, if we can really hone down exactly what we want as a board, if we choose to allow people to use that logo, what we as a board require for the use of it, those being those disclaimers, or from the desk of, or this is my opinion somewhere written in there, that I'm not acting on behalf of the board written in there. Because for me, I do see value in being able to use a logo. We've all been elected to this office or this position, and you know, we are representatives of Ottawa County. We just have to be very specific when we're representing our own views and not speaking on behalf of Ottawa County as a whole. So that was my thought on that one. And I, you know, there's been a lot of calls, and I understand it, for disciplinary action of those who have used the logo. The challenge for me is, yes, we have 3.1, and it does say that we are speaking on as a board. I need some substance down below that before I can say, you know what, your speed limit posted was 70 and you were going 75, so you get a ticket. We haven't articulated clearly in this issue, hey, if you're going to use the county logo, it means A, B, and C. And if you don't do A, B, and C, then the consequence is this. So I'm very frustrated that Joe used it initially in the way that he did. But at the same time, we don't have a specific outlined guidelines for commissioners on how exactly they should use that. And times have changed. And in the past, it was common sense practice not to do so. It's a little different now. So if we're going to agree to use it, we just have to put some guidelines there. So that's my thoughts.
Your comments?
Sure.
Mr.
I 100% support the idea of commissioners being able to use their voice. Let me start from there. Same time, I don't like, as a citizen, government telling me what to do or how to run my business or how to think when they don't have jurisdiction over that thing, whatever that thing is. A lot of us happen to run for office because we felt like the government had overstepped and spoken into things they shouldn't have been speaking into, specifically the county government, right? And yet here we find ourselves, you know, now that we're elected, Commissioner Moss, who didn't like the county speaking into how Libertas should function, Now he's speaking into GVSU and telling them what to do. It's just interesting, to look back on it. When we're private citizens, we should absolutely voice our opinion. But when we become elected officials, we need to remember that because we are elected officials, we carry a certain responsibility. Our voice matters in a different level because we represent something bigger than just an individual, right? We're representing our entire district, in my case, 28,000 people, and then it's presumed the 300,000 people on top of that. So we just need to be careful that we don't become the thing that we say we're against. In some cases, we as a county provide funding into these organizations. And I think it's proper that we ask questions to provide oversight to say, hey, how are you using our funding? Because we have a vested interest. In this case, I'm not aware of any funding that we give to GVSU for any of these programs. Maybe there is, but I'm not aware of any. So I think that we are overstepping our authority as individual commissioners when we speak out on these things on county letterhead. If we're writing as a private citizen, perfect, absolutely, but we risk this kind of chaos. And the fact that it ends up being plastered all over social media, if this is a private letter between a commissioner, presenting their point of view to an official at another organization, it should be kept as a private matter. And then if you want to, celebrate the success of what fruit has come out of that conversation, great. But to do it, in my point of view, as a grandstanding public media stunt, I don't think that this helps our cause. I think that this hurts the conversation because it creates more division around the topic versus working with each other to find a reasonable place that we can function and work together.
Well said, thank you.
Yeah.
I also attended, go ahead, so, Roby.
Okay. I actually have a lot to say on this, so give me a minute. First of all, you guys are suffering from Moss derangement syndrome. You just are. This is silly.
From what?
Your Moss derangement syndrome. You are overreacting to minuscule things. My 10-year-old last night asked me, what are you going to talk about at your meeting tomorrow? And I said, well, whether or not we can use a logo. And he said, where are your laws on that? And I said, well, there really aren't laws on that. And he's like, well, where's the book, that tells you what you can do and not do? And I said, well, we have policies. And he said, well, you should ask them where the logo law is, and he's right. These are very simple things. And we're getting all worked up over silliness. So I'll start there. We are elected to the Ottawa County Board of Commissioners, just as other people are elected to other positions. They freely use the logo in their communications. There's no reason why we as elected representatives shouldn't be using a logo to the county that we were elected to represent. Why has this not been done in the past? I don't really know why it has not been done in the past, except that I think that our commissioners have not recognized that they have a voice in the community and that voice matters. And when you're elected to represent people, you have a responsibility to use your voice, and we should be using our voices. I don't think that you are giving our citizens enough credit. We have smart citizens here in Ottawa County. We're one of the most highly educated counties in the state of Michigan. And I think that they can tell that when there is a name on the letter, that the letter is coming from that name. Now, if a letter has, multiple names on it, they can recognize this is coming from multiple names. If it's coming from the board or the board chair saying that it's representing the position of the entire county, they can figure that out too. But I think that you're making assumptions about the cognition of our constituents that is just wrong. They can completely tell who a letter is coming from. If there was a quorum of signatures on a letter, then we'd have an Open Meetings Act problem, but there's not. I just want to point out an example because there's lots of examples of this. So on April 4, Representative Bill Huizinga put out on Facebook that he had sent a letter to the Honorable Jocelyn Benson. Now, I would argue that Representative Huizinga is going to have a very difficult time getting Jocelyn Benson to do anything that he tells her to do. Does he have direct authority over her? No. But does he have a position where he can speak into his concerns and the concerns of the people of Michigan to Jocelyn Benson? Absolutely. And so he has written a letter to her using the logo of the Congress of the United States. And he's joined in that letter by seven other congressmen and women from the state of Michigan. And so he is elected to a body that acts as a whole. They take collective action, just like we do here. You see the same thing on the state level with our state legislators. They are part of a collective body. Their authority is as a collective body. They work together, and that's where their authority is, just like here. They also routinely issue letters using logos of the state, of the legislature, when they speak into issues in their communities, issues that they do not independently as a single person have any direct authority over. But as elected representatives, it's our job to listen to our constituents and to speak for them and to advocate on their behalf. But when I wrote a letter to Grand Valley, it was because I have been speaking with my constituents for months, and I've been hearing things that are really heavy on their hearts. They're facing things like discrimination, violation of civil rights, freedom of speech, conscience, and religion, things that have risen to the level where there's investigations going on into Grand Valley. But I have personally witnessed this affecting them as individuals, multiple individuals. And so, yes, I'm going to write a letter on their behalf, and I'm going to ask Grand Valley to take a look at this because it's affecting my constituents. Do I have direct authority to force Grand Valley to do anything? No. But I'm a voice for my constituents. And is that appropriate? 100% it is. And so I don't think that anyone would think that I'm writing and speaking for this entire board. You know, if Commissioner Zylstra wrote things using a logo, I'm probably not going to agree with everything he has to say. And that's okay, because he's representing his points of view and his constituents. And it's 100% appropriate for us as commissioners to be writing letters on behalf of our constituents and speaking for them. When Commissioner Moss wrote a letter to Grand Valley, I can tell you, because I've spoken with his constituents, he was speaking for them. He has constituents who live in his district, who go to Grand Valley, who are struggling with these same things. It was 100% appropriate for him to be their advocate. So, you know, when you think about the logo is also in our emails. So what are you going to do? Are you looking at our emails? Somebody going to babysit them? Do we need to have votes on the emails that we send out that have logos on them? I mean, how far are we going to take this? It's this, again, this is just completely silly. So we're not prohibiting our other elected officials from using a county logo. We're not approving what they have to say at the board level. I just think this has been blown out of proportion, and it doesn't need to be.
No, I appreciate that, Commissioner Ruddy. In 2021, the board voted to place restrictions on how we did resolutions, and we voted to restrict them to county-type matters, operational matters, and I voted against that at the time. In 2023, we reopened that discussion, and one of the things Commissioner Moss said at the time, and I think something I agreed with, is that he said, one of the things that I know a number of people on this board have advocated for in the last couple of years is that citizens use their voice. I think it's great that the board also be able to use their voice in important issues, whether it's Second Amendment, parental rights, the Constitution, or whatever the board may take up. I agreed with him on that statement. I agreed with him on the vote. I voted to reopen resolutions without restrictions. But I think what we've seen over the last 3 weeks is, last 2 weeks is 3 members not affording themselves that opportunity that in 2023 we gave them to use resolutions, to speak collectively. I totally agree with a lot of what you said. We have commissioners who are elected to speak, and that's why I was against closing it down in 21, and why I was in favor of opening up resolutions to any matter in 2023. I guess my question is, why was that ability not taken up by the 3 of you? You could easily have done that, brought a resolution with all these concerns and spoke to your concerns through the board collectively, like 3.1 says. But that wasn't done. And I think that's what, for me, is most disappointing. I understand the logo and what John says about it being a public asset. It makes a lot of sense to me. But at the end of the day, we have this power to do resolutions. In 2023, we opened up that to any topic. And I guess I'm just disappointed that the mechanism that we have as a board to collectively speak was not pursued.
Well, I appreciate that, and certainly a resolution could happen as well. But
Why did that not happen instead of the 3 individual letters?
it doesn't have to. It doesn't have to. And I don't expect, well, for one, I can speak for myself. For one, you don't know my constituents. You do not have the experiences that I've had with them. I don't know if you read my letter, but it's 4 pages
I did
long.
read your letter, have it right here. So, yeah.
And so I don't expect you to agree with everything that I felt needed to be said to Grand Valley on their behalf. And so I think there can be 2 different things. I think that, yes, absolutely, we can bring a resolution. If you guys want to do a resolution for Grand Valley, I'm happy to bring one.
You're welcome to bring one.
And
You have that power.
But I also have a voice. I have freedom of speech. I represent constituents. I was elected to represent my constituents, and I'm going to use the position that my community put in to speak for them on their behalf when they have a need. And so, I'm happy to do both, but I both individually represent my constituents and I work collectively with the board on collective actions.
Okay.
But one does not preclude the other.
So in 2020, in the summer of 2020, Chair Bergman, Commissioner Garcia, and myself had some conversations about, what the board's response should be to the George Floyd incident and, BLM and, everything at that time in June of 2020. And we worked on a statement with the DI department and had a statement that, we 3 were proud of. But in conversations, it was apparent that, the board did not want to, speak in the same way. And there was a brief moment where we kind of considered our next steps. And one of the next steps was, should the 3 of us have a joint statement? I think very, very quickly, the 3 of us realized that having a joint statement with 3 commissioners was not only breaking 3.1, but breaking the spirit of the board, right? And I know you've talked about Representative Huizinga, but from school board to county commission, that is a unit of government that I think is different than Lansing or different than DC, right? They have autonomy in a sense that we don't. We get our powers from being members of a board. Obviously, we're all commissioners, but we are elected to the Ottawa County Board of Commissioners, right? And I think at the end of the day, we have had 3.1 for many, many iterations of the board rules for a very simple reason, is that maintains us as a board, maintains us united. We can speak as one if we all agree to it, or majority of us agree to it. But once we start saying, I want to speak to this issue individually, I think not only does it break 3.1, but it breaks the idea of the board as a unit. So that's why I'm against it. I think the logo, part of the discussion is interesting and the fact that it's a public asset. But, having been minority member since day one, I obviously have not agreed with a ton of all decisions, right? But I've always said, the board agreed, the board voted, the board did this. Because I believe that we are one body. And when we start acting individually, we're breaking that bound.
Mr. Chair.
Commissioner.
I would first just ditto Commissioner Rohde's comments. I think they were very well stated, so I'm not going to belabor. Excuse me, I have the floor at the moment. I'm sorry. That was very rude.
You know what? She was very rude.
Excuse me, Mr. Chair. I'm pleading to the chair here a minute. Am I the
Plead
one
away.
speaking right now?
The floor is Commissioner Meeting.
Okay, thank you. So I just really appreciate the comments you had. There are a lot of the ones that I had prepared. I don't need to say all of them all over again. One thing I'm going to say is that Commissioner Zylstra, you had mentioned that we're a different elected body. Every state rep and every congressman, they all are elected, just like we're all elected. They form a body, we form a body. Yet we all have our own unique roles that we play. And so for you to say that we're somehow different in them, yes, we have different responsibilities, absolutely. But we are all uniquely elected. And so I very much argue that point that Commissioner Zylstra brought up. I again want to bring up our freedom of speech, our ability to speak into our community, using our voice is very important. I'm very surprised that no one on this board has been asked to write a letter before for anything. Like I'm surprised that Commissioner Kyers, if you haven't ever been asked to write a letter of support for anything in your 20-some years being on the board, I think that's pretty common practice that an elected official would be reached out to by somebody to just say, would you be willing to put your voice on behalf of this effort that we're working on? That's not something that we took as a vote. It's not something that's contributing funds from our county. That would be a different matter. But just using our voice, that is completely different. If you look at our emails, like what Commissioner Rohde was saying, we have our logo at the bottom of our emails, or you have the option to have your logo. Do we need to have a disclaimer that says, but this might not represent the entire body? I mean, that's just silliness. I think Commissioner Rohde was right on point that when this started was because there's members of this board were upset by who started the process of having a letter that was put out on social media, and that was Commissioner Moss. Moss derangement syndrome is a very well-spoken thing by Commissioner Rohde, because I think that's actually what is happening here. And I'm disappointed in this board. I'm very disappointed with the manner and that you guys have brought about. Earlier today, Commissioner Berger asked us to table an update to rules of Ottawa County Board of Commissioners so that Commissioner Moss could be here. But you didn't ask to table this one when he's not here and hear you talk about Commissioner Moss over and over and over again. And you didn't even allow me to speak to your item about why you were tabling earlier. I'm sorry, we have to go right to a vote. While that's true in Robert's rules, I mean, very disrespectful to Commissioner Moss with bringing him up saying, we just had a great coffee and I think we came to a great understanding together. Very inappropriate to talk about Commissioner Moss in that way, for him not being able to be here to speak for himself. So again, I am disappointed, very disappointed in this board today.
Any other comments?
Sure. The reason that I made the motion to remove item 2 so that Joe could be a part of that conversation is because it's a significant issue for Joe to be a part of. And actually, John and I, and well, not John and I, Phil and I, we all talked about this topic being on the agenda for the Planning Commission, and we had actually removed it. In the first iteration, it wasn't on it because Joe wasn't going to be here. But then Allison, you wrote a letter, and Sylvia, well, you wrote your letter, and so we thought, well, all right, somebody's going to be here so we can discuss it. That's why I didn't vote to remove it from that one. But you could have made the same motion to table it. It's fascinating to me. you know, and I understand Jacob's perspective, I understand Doug's perspective, Sylvia, Allison, all your perspectives, absolutely. Where I struggle, and I don't know if Sylvia and Allison, you realize this, and maybe this is just me, but when out of the gate, John and I and a number of us have been very conciliatory, even our conversation with Joe, at trying to find some common ground, trying to find a solution to move forward, rather than get into the weeds, if you will. Come up with a solution that doesn't punish anyone, that doesn't unduly hold somebody to some standard that doesn't exist yet. And we're trying. And then out of the gate, we're told that we're suffering from Moss derangement syndrome. And out of the gate, we're told that we're silly, Sylvia. It's hard for me to hear everything that comes after. So I hear it. And ironically enough, we're very similar on a lot of things. But when I'm being called names or being called delusional, right out of the gate, it makes it really hard. So I just want you guys to know that the Herculean effort it takes from all of us who are being called names and being told that they're ashamed of us, to continue to take the high road, to continue to look for common ground, it's not an easy thing to do. That's all I want to say.
Well, while I respect that, this is an issue it's a non-issue. This is a matter of individuals wanting to exert control and squash the voices of other individuals. There's a desire for absolute control here on this board from people who ran for good governance, and so that people could speak. And somehow we've become this authoritarian state. You've become the things that you were accusing Joe Moss of. I don't know why you feel that you need to control everybody's speech. This is just going a bit far. It's completely unnecessary.
Richard Eagles.
So I've had 10-to-1 communications from my constituents on this issue versus the Campbell plant. And yet we spent all that time on Campbell, but this is the issue that people, and so Commissioner, so you say that this is silly, to me shows disrespect to my constituents who say this is not silly, that are pounding my emails and voicemails, right? And I'm here to represent my constituents who are asking us to address the issue. The fact that we're discussing it is important, right? From day one, I have balanced every committee. I have not excluded anyone, and to try to keep this voice going, right? My attempt in my effort to meet with Joe was a really positive one. It was really positive. And to suggest that his example of the letter, which is what people want to talk about, shouldn't be talked about? No, it's the impetus for this conversation. It just happened to be Joe. It could have been you or somebody else. And all I'm doing is creating a conversation, and like Commissioner Berger just said, try to find a solution that can work for all of us and be representative of the community. That's the objective. It's not to shut anybody down. It's to find something that's common ground for this community, to unite the community and not further divide, which has been the case for 2 years.
I would just further say that I think that this whole issue is a reflection of where we have come to be as a culture. And it has definitely impacted Ottawa County. So when you have initiatives and cultural movements like DEI, there comes to be one accepted belief system. And only those specific beliefs are acceptable to be stated out loud in public. And anything that differs from them is not acceptable. And so a lot of our constituents in this county, when things are said outside of that box, they become highly offended by those statements. And so I would just argue that I think a lot of what we're hearing is actually not about the logo. It's actually about not agreeing with the content of the letter. And so, and it might be boxed up in a package that this is the logo, don't let him use the logo. But I think they wouldn't really mind the logo if he was saying something they agreed with. And so I think we need to be careful about, content, and conservatives need to be able to speak their minds. And in America, they're not able to anymore without people becoming very, very upset. And whether it has a logo on it or not, I would argue that the same letters could have been issued minus a logo, and you probably would have had a full email box still. And so I just think that we're treading on some shaky ground here when we're getting into, trying to talk, push too far into what people can say and not say, and, what it can have on it. I just think it's a bigger issue than what it's being made out to be.
So you haven't, at least from my
Mr.
perspective.
Chair.
I'm sorry.
Just a minute, Mr. Tepos, Commissioner Wenzel had
I'm
his
sorry.
hand. Wow.
I was debating on bringing this up. You just spoke, I think this needs to be addressed. It's not easy for me to bring up. You had said that you were trying to be fair, balancing the committees, et cetera. We had a conversation in our side office back here during that time that you were trying to be fair and balance committees. You wanted to remove me from CMH and the VA. I repeatedly told you statutorily I was still on CMH, and I was trying to figure out if I was statutorily on the VA. And you told me to get ready for a fight. And I said, Mr. Tepos, why would we have a fight about this when by statute, I am still on these committees? And you went round and round and round with me about that. And you put your hand at me and said, I'm done with you. You walked out of the office, and I said, that's unfortunate. I think we should continue this conversation. You went that way, I went that way. And when I went that way, you started raising your voice to me, and I thought, he's addressing me again. So I turned around and you said, Kendra, pointing your finger at me, you are so black and white. You are just like my son. And you went on to describe that. That is not being fair about the committees. That is not going by statute for the committees. I think it was dishonest of you to say just now that you have tried very hard to balance the committees and be fair. I was being fair. I wanted to go by the statute. And you wanted me to have a fight with me about that.
Yes,
Mr. Chair.
Commissioner Muda.
Okay. I want to add on to what Commissioner Rhodey was getting to, speaking that this is really not about a logo. This is about the concern with what we are choosing to write about in our own voice as a commissioner. And I'm just using a part of Commissioner Bruger's, what he wrote on his own commissioner page. He said, while all speech is protected, when we choose to sign off as a commissioner in an official capacity, by way of utilizing letterhead that represents more than just our individual selves, but rather an entire county of over 300,000 people, the content of that letter carries additional gravitas. As such, we must consider carefully the content of such letters. And I believe that is exactly why some members on this board are making such a big deal about our choice of writing a letter from our own elected official capacity. And it's not about the logo itself. It is about the content that has been utilized in speaking out.
Any other comments?
That comes, but I don't know if John wanted to get into respond, Kendra.
So at least from my perspective, content was immaterial. You haven't heard me say anything about the content. As long as it's clear to the public who's speaking and from what capacity, do what you need to do. I'm not overly concerned about content. Commissioner Wenzel, I'm not going to respond. You have a different interpretation of that discussion. I'll leave it at that.
I'd like to make any more comments or we'll move, go ahead.
I'd just like to put a
Commissioner
couple
Barry.
things on record, I guess. I want to 100% say and support freedom of speech, that people have a right to say whatever they want. I do have problems if it implies it comes with the authority of county government here. I think we can find some reasonable guidelines, even something as simple as from the desk of, with the individual's name and the districts that they represent would be fine. I would think most of these correspondence could be just, congratulations on your 50th wedding anniversary, or congratulations on winning the state championship, or something along those lines. But if people want to write about issue things and it's clear that they're speaking as an individual, I would support that. So I'd like to find a way to do that. I don't really think this has anything to do with DEI. It's just who appears to be speaking for the board, and can we make that a little more, separate that out a little bit more, make that clarified. Commissioner Rhodey, I just wanted to speak to, you mentioned the correspondence from Congressman Huizinga, my brother, but anyway, I'm not familiar with this specific correspondence, but it sounds like it was probably Republicans in the Michigan caucus in Congress that wrote to Secretary of State Jocelyn Benson. While they don't have oversight or supervision of her, because elections in Michigan are administered by Secretary of State Benson, they certainly have standing in a discussion and being able to appeal to and speak to the Secretary of State on that. So that's an example where they clearly have standing in taking on an argument. Again, I'm a small government kind of guy, and I don't think it's our business to tell companies how to run their business and or organizations for that matter, unless we have some connection or oversight on it. But there's freedom of speech, and people have a right to be able to express their opinion. I rest my case.
I appreciate that. And I do agree with you on one point in that I think it is important how we say things, if we are saying things. So I don't know if you have an opportunity to read my letter, you will notice it says I respectfully request. I think there's a difference between, I mean, I don't think it's appropriate for us to say, I demand you do this, that's not appropriate. But I think that we can use the kind of language where we can definitely express our opinion and appeal to entities that we don't directly govern about our position. But to your point, I agree. I don't think we should demand things of people that we have or entities we have no control over. However, we can request things respectfully.
Just one last thing. I just want to say that just to keep in mind for this board, where in the law does it say that we can't use our power in this way? I'd like to be able to see that. And you're not going to find it.
Yeah, just briefly, I agree that this issue shouldn't really be an issue either. To me, it's such an easy compromise. Like Commissioner Barry said, you just put from the desk of. Frankly, I was impressed when I saw that letterhead, because I didn't know that we had our own personal letterhead, and I would absolutely use that for, wedding anniversary or business openings or state championship congratulations. So I think the reason this discussion is happening, in my opinion, is not to shut down anyone from being able to say what they want. It's saying, hey, we could and maybe should have this resource, all of us, and let's in the meantime just make it clear for everyone in the county exactly what it is. So I just don't see an issue with putting from the desk of on this letterhead. That's where I come down.
Thank you. I kind of agree with that, and I'd like to move it forward to the full board as maybe we just, as Commissioner Brewer suggested, maybe we just put a few things in the bylaw under 3.1, from the desk of your own personal opinion. I would agree with that. So if that's something we could work on, I'd appreciate that. So thank you. Thank you for all your comments. Let's move on to Health and Human Services updates. Public Health, Adeline Hambley.
Morning.
Good morning. Before you start,
Yeah,
I'd like to say congratulations.
thank you.
It's really a privilege that you get to get the award from, let me find the name of that award, the Jean Chabot Health Policy Champion Award. They just talked about at the state health meeting.
Yeah,
Adeline went above and beyond to give services and care about the health of the people in the community of Ottawa County. So thank you very much. And
Thank you.
congratulations.
thank you very much. So I'm going to turn my time over to Dr. Unsicker. As you may have heard in the news, there's a measles case in Kent County, one in Oakland County, and then one just this week in Macomb. And so she is going to give a measles update, kind of related specifically, more specific to Ottawa County. So I'll turn my time over to Dr. Unsicker.
I'm a little shorter than her, so fix that. Can you guys hear me okay?
Yes.
All right.
Yes, thank you.
Thanks. Well, thanks for letting me be here to talk about measles this morning. Some of your faces are new to me, so by way of introduction, my name is Dr. Gwen Unsicker. I'm a family physician. I've been with the health department for about 3.5 years, but I've been here as a physician in West Michigan for 20 years, and it's really weird for me to say that now. I did want to just take an opportunity not to raise alarm, but actually just the opposite. Our mission at the health department is working together to assure conditions that promote and protect public health for all. And that's exactly what I want to do today. I want to provide some information so that we can all be prepared, not scared. So I want to start with where we are right now nationally and a little bit more locally. As of April 3rd, which was on Friday last week, the CDC had reported 607 cases of measles across 22 states. These numbers are actually higher now, but the official count doesn't get updated until Fridays at noon on the CDC website. So that official number will be higher tomorrow when that is updated. There is an outbreak in Ontario with cases in Windsor right across the border from Detroit. And there's also an ongoing outbreak in Ohio. And where it becomes particularly important to us is actually, I have an update since Officer Hambley gave you the numbers here in Michigan. We now have 4 confirmed cases here in Michigan. There was one confirmed. The first one was in Oakland County in early March. That was with someone who had traveled internationally. Then April 1st, Kent County announced their first case of measles in over a decade. Macomb County announced a case in someone who had traveled to Canada on April 4th. And just yesterday, a 4th case was announced in Montcalm County, which is not as close as Kent, but almost. So these cases, as they get closer and closer to home, and with measles being so incredibly contagious, this is definitely something that we need to be aware of. Again, this is not to cause fear or panic. It's just to raise awareness so that we can respond and not react. There are no cases in Ottawa County at this time, so let me be clear about that. So you might be wondering, why do we care about measles? Isn't it just a little rash? Well, one expert notes that measles thrives on being underestimated. We've probably all seen the Brady Bunch episode where everybody gets the measles and they get to stay home for a week. Sounds fun, but I want to get a little bit more information out. So again, people can be aware, not scared, and not panic. Measles is actually the most contagious virus that we know. Up to 90% of people who are exposed without any pre-existing immunity will become infected. And the virus can remain contagious in the air for 2 hours after a person with measles leaves that airspace. So it's very important that we're aware if someone who has had measles has been in an airspace and make sure that the people that are in that place have evidence of immunity. Right now, the current outbreaks, about 12% of the people that have been infected have needed hospitalization. The most serious complication from measles, other than death, unfortunately, is pneumonia. About 1 in 1,000 cases lead to brain inflammation that can cause permanent damage. About 1 in 10 kids that get measles will get ear infection that can sometimes lead to permanent hearing loss. And it can also affect our immune system in a way that is something called immune amnesia, which essentially makes the immune system forget how to fight infections that it previously knew how to fight. And this effect can last for several years after the person recovers from the infection. It's especially dangerous for pregnant women, babies who are too young to have been vaccinated, and folks with weakened immune system. Before vaccines, measles caused 400 to 500 deaths a year in the US. And unfortunately, this year, we've already seen 3 deaths associated with this outbreak, including 2 children. So preparing for outbreaks is not the most visible part of what we do. You guys usually only see the response to the outbreak. So I wanted to give you a little glimpse into what we've been doing to prepare. We've been really busy at the health department making sure that our healthcare system partners are aware of what's going on so that they can be vigilant. We've sent detailed guidance to our healthcare providers. We've been having meetings with our healthcare system partners to make sure that we're all aware and know what to watch out for. We've started conversations with school districts about their protocols, and we've been updating our response plans. Our last case of measles in Ottawa County was in 1991. And as I said, I've been here 20 years. I was not a doctor yet in 1991. So this is something that, again, we are preparing for the worst, but hoping for the best. So our staff is meeting regularly to review our processes, such as following up on any exposures that we are aware of, any cases that need monitoring, and any kind of treatment. We're actively working to ensure that we have adequate vaccine supplies and other treatments available if we need those in the case of a case or an outbreak. We've been coordinating with our healthcare systems to provide for treatment processes if exposure occurs. And we're staying in communication with our other health department and state health department colleagues for consistency and collaboration across county lines, because measles does not recognize those county lines. So there might be some practical things people are wondering, what can I do to be prepared, not scared? First of all, check your immune status. Make sure if you have been vaccinated that you and your family are up to date on those vaccines and have documentation of that immunity in case you're exposed, because this can help guide what preventive measures may need to be taken if you are exposed. Know the symptoms. The early signs look, unfortunately, just like a cold, so it can be hard to tell early on. Early signs can cause high fever, cough, runny nose, red eyes, and the rash doesn't actually appear for about 3 to 5 days. And during that time before the rash shows up, people can be contagious, which is why it's so tricky to find out if you've been exposed, and it's important to know your immune status. If you think you have been exposed and you aren't immune, we want to emphasize that it's very important to call whatever healthcare provider's office or facility that you're going to before you go. Because this can be contagious for 4 days before the rash shows up, we want to make sure that the facility is able to prepare for you to be seen and evaluated in a safe way to avoid exposing anyone else who might be there who may not be immune to measles. And then, of course, we want people to be able to get reliable information. So we have updated our website to provide current information about measles. MDHHS has information on their website. The CDC has information on their website. And also, of course, we always recommend consult with your own healthcare provider. I mentioned that there are some options available if you're exposed and you're not immune. So if you know that you've been exposed and you don't know if you're immune or you know that you're not immune, getting the MMR vaccine within 72 hours of the first exposure can often prevent the disease or make it less severe if you do become infected. And for some high-risk groups of people that can't get the vaccine, like pregnant women, infants that are too young to have been vaccinated, or people with severely weakened immune systems, there's something called immune globulin that can be given up to 6 days after exposure. And again, this can help prevent the disease, or it can help make it less severe if someone does become infected. And our department is working with our healthcare system partners to help arrange these preventive treatments if they become necessary. I do want to acknowledge that I know we have very diverse perspectives on public health perspectives in this community, and we respect that diversity. Everybody's healthcare journey is different. Different values guide our decisions. And again, as a 20-year family physician, I've had so many one-on-one conversations with patients about this. And that really is the best way to have these conversations, right? Michigan law does provide for non-medical waivers as a personal choice We honor that at the health department. We have a process for that. And with that choice comes a shared responsibility. If we do have measles cases here in Ottawa County, there are other temporary preventive measures that can be taken to help prevent the spread of measles. Some of those measures may include temporarily removing an exposed non-immune person from a shared airspace, which may include school. And this is a protective measure, not a punishment. It's a protective measure for both the child who's been exposed and may not be immune, because they can be closely observed, they can get care if they start developing symptoms immediately. And it is really to help protect the broader community, especially those that didn't have the option to make that personal choice not to vaccinate, such as babies that are too young to be vaccinated, people with medical conditions that prevent them from being vaccinated, and those who have severely weakened immune system. Keeping that exposed non-immune person out of the shared spaces is a shield of protection for those whose health depends on the actions of others in the community. We do discuss this possibility during the waiver education appointments so that families can plan ahead and be prepared. And that's one of the reasons why we're talking about it now, so that people can know that, yes, you have made this decision. We know it's a personal decision, but we also want to give you the information you need to know how to prepare if that decision affects others in the community. We try to balance this approach as a way to respect individual choice and acknowledge that we are all neighbors and we need to watch out for our neighbors, particularly the most vulnerable. Again, back to our mission statement at the health department, working together is essential for protecting public health. It's right there in the mission statement, and we're committed to serving this community with respect, transparency, and compassion as we navigate this situation together. And we will continue to keep everyone informed as the situation unfolds. So thank you for letting me give that update.
Thank you for your information and knowledge about measles, and it is something we have to watch and take care of. So, any comments or questions, Jacob?
Yeah. Doctor, thank you for being here today. And this may be a question for Addie as well. Addie and I spoke at length last year about the non-medical waivers and the stress that it puts on your office, because we're all human and we all procrastinate when our kids are going back to school, and most of these waivers are all done. Hundreds of them are done in the 4 weeks before they return to school. And not everybody gets processed in time because there's not enough staff to all of a sudden deal with that. So the solution that we discussed was the non-medical waiver that could be obtained online. And you've been looking into that a little bit. So two-part question. First is, do we have a status update on if that is going to be available for this school year? And then the second thing, does it address some of these trends, risks, when people are doing the online education part of it before they make their informed decision? Does it talk about these are the current risks that we are seeing in our community so that they can have that information when they decide whether or not to pursue the waiver or not?
So I can answer the second part first. I can give just the teensiest update on the logistics of it. MDHHS is getting on board with this idea too. There are a couple other counties that have implemented it with great success. And so we are very excited to potentially adopt this as a way to, provide the information for folks, but also reduce some of those barriers. Just like you said, August is a really, really tight time for getting in at the health department. Our immunization team is a dedicated group of nurses who are also moms whose passion it is to share this information with people. So you asked if that information is shared. Yes, the point of these visits is not to try to change people's mind. It's not to try to convince people you have to get vaccinated. It's to share that information one-on-one, like I mentioned, and to talk about what are your family's values? What else influences your decisions to make this choice? We know that people have had negative experiences with medical interventions, and we want to honor that. We want to hear that. And we also want them to be prepared for what happens if they do make the choice to not vaccinate, because it does come with some shared responsibilities, like we talked about. And so, again, this is something that is for protection, not punishment. And I believe that most of the folks that have come for a waiver visit have been pleasantly surprised that it is not about trying to change your mind. It is not about shaming. It is about providing information, discussing individual concerns, and really letting people have those options available to them. So I again, I'm very excited about the fact that the online option may really decrease that bottleneck right at the beginning of school. But that would not replace the waiver appointment for anyone that wants to have that individual conversation with one of our immunization team, because they are passionate about making sure people get the information they need. Is that helpful?
Yeah, I guess thank you for sharing that. I appreciate hearing, what's driving this, that you really want people to feel welcome to have the conversation, that it's not going to be a debate, that you just want to be helpful. So that's really important to get out there. But the conversation where you allow somebody in conversation when you're physically with them doesn't necessarily translate to online. And so my question was more along the lines of, that's really good information for somebody and helpful information to have that they're getting in person, but is that going to translate, or how is it going to translate through the online portion of it?
So I think some of the one of the counties that has already implemented, they use, and this is what we're looking at as well, like an online training module program. I don't know, do commissioners have to take the IT security stuff? Have you guys had to? Yeah, that's kind of like an online training module, right? It's so similar, like there's videos and then you have to do quizzes, right, about what was in the video. I believe it's set up very similarly. And then how that works, because the law requires that there's still the local health department signs off on that. So somebody could take that module remotely on their computer, and then they just stop in the office for the signature. So it doesn't absolve the requirement in the law for that health department sign off, but all of the materials, when I have seen what Livingston County has done, it's very similar sort of style of like videos and then questions or quizzes kind of things in between. And then the state, as Dr. Unsiger said, is working on actually implementing and rolling out like statewide. Because of the success of the Livingston, I can't remember what other county, I know Livingston for sure, that they've had using this. And so we're working on kind of side by side. So, because sometimes the state can move slowly. So, because we would like to have something in place before the school year. Yeah. So
do you think it's possible that we would have that to offer parents before?
that's our goal.
Okay.
Yeah. Yeah.
Doctor, I just want to say thank you for your work and for the others that are doing the work. It seems that you come from a very compassionate standpoint. Some things that I'm just asking that you would consider how you presented today, just to think through a little bit. You had mentioned doing things for one another. It's like the kindness that you're doing this for somebody else. And one thing I just want to ask is that you mentioned the possible ramifications of I'm not using the same language you are right now, so forgive me. But if they don't get a vaccine, but what I didn't hear you say was the potential side effects from them getting the MMR. And there is a whole list of potential side effects, just as there's potential side effects the other way if someone chooses to not get a vaccine. And so I want to make sure that as you're carrying on these conversations with you or whether it's your staff, that is one of my concerns, that I have it's being presented in a fair way, because I still heard it from a one-sided perspective here, if I'm going to be very honest. And I really want to hear both perspectives, that I can't even know what your ideology is on it, that you are presenting both, and that the person coming in, that they are making the best decision they know based on information that's being provided, and that they're taking the time to research. And so one of my concerns I did additionally have as you spoke, and maybe you can just clarify for me, it might have just been a misunderstanding. Is it the health department's perception at the moment that if someone chooses not to give their child an MMR vaccine, and that they're going to now ask those children to be removed from the classroom, only those who are unvaccinated?
So let me clarify a couple different things. So first of all, thank you for mentioning the conversation about side effects of vaccines, right? So in a forum like this, where we're, trying to give a very broad overview. That, again, may not be the best forum to give all of the information at once. And that's one of the reasons why we have the opportunity for people to have those one-on-one conversations, because some of that information may look different depending on what a person's medical history is, what their previous experience has been with medical interventions. And so again, that's where some of that personal conversation can come into play. In terms of the side effects of the vaccines, that again, risk benefit conversations are tricky to have on a broad scale, because a lot of times we're thinking about what is the risk of getting the vaccine versus the risk of getting nothing. And what we in public health have to consider is what is the risk of getting vaccine and having potential side effects versus the risk of getting measles and having an outbreak. So we're looking at it from that perspective at the public health level. But again, having that one-on-one conversation is so important. And, if anyone would like to sit down and have a cup of coffee and talk about this, I would welcome that. I mean, that's basically been my job for the last 20 years, is to have these conversations with individuals, right? Now, in terms of the health department position about what would happen if someone is exposed to measles and they haven't been vaccinated against measles or have no evidence of existing immunity to measles. Public health for decades has used other alternative means of outbreak management. And part of that is removing a potentially infectious person from the environment where they could spread that to others. We make it as targeted and as least restrictive as possible. And measles is something that has been around for a long, long, long time, but hasn't been as prevalent because it was eliminated from the US in the year 2000. So again, backing up a little bit, the targeted outbreak management would include making sure that the person has a confirmed exposure to a confirmed case of measles, making sure that we do everything we can to ensure that we have any evidence of immunity, whether that's from vaccination, previous infection, certain age groups, none of which would be students in schools, but maybe some staff members, are considered immune just by virtue of having been born before 1957. But again, we try to cooperate with the schools, with the families, make sure that we're doing whatever we can to make sure any kind of outbreak management in the case of a measles exposure is targeted, limited, and is safe for everybody that's involved. Is that helpful? I know I said a lot.
Yeah, you did very well. I'm wondering, so let's say that hypothetically there was a case where all the kids in a particular class were exposed. I would assume our health department's stance on that would be having all of them not return versus only a select few, like for a certain amount of time, that you would, instead of just those who maybe did not receive the MMR vaccine.
So if we have a classroom full of kids and say there was someone in that classroom that had measles, right? And so let's say that happened on a Thursday morning. We know that student A was in classroom and 20 kids in the class, right? All but 2 of them have had their MMR vaccine. The 2 that are not immune, those would be the 2 that would have to remain out of that space for the limited period of time to A, monitor them for any kind of signs and symptoms of measles during that incubation period, and B, make sure that they're not exposing anyone else in that classroom who may be vulnerable if they should develop symptoms before the signs show up. So again, it's only those that don't have evidence of immunity that are removed from that space. But that again is the alternative. That's what's kind of talked about in the visits with the education about waivers. That's the alternative means of prevention if people choose not to have a vaccine, which they are completely within their rights to do. But there are other alternative methods that we have to employ then for public health to make sure that the patient is being monitored and that they are not exposing others to the risk.
I do have concerns there, but my other question is, what preventative measures besides the vaccine is our health department suggesting for others to keep healthy? And besides just going one full in just on the vaccine?
Sure. I mean, all of the stuff that applies to staying healthy from and, staying away from other germs applies, right? So making sure you're eating well, staying hydrated, getting good sleep, avoiding stress, right? Haha. Those are all the good things that are useful in just helping people stay healthy in general. The vaccine is the most effective means of prevention that we know of. And again, I know we can talk about the concerns that people have, and I don't mean in any way to minimize or discount those. From a public health standpoint, though, the most effective way to prevent the spread of measles is to have as many people in the community immune as possible.
I might like to grab coffee with you sometime, because I would say that I probably disagree with what you're saying, but I do appreciate what you're sharing.
I love coffee.
Commissioner Lilly.
Hi, thank you for sharing this information. And I have to say that I appreciate your tone and your presentation, as I see that there have been improvements over the last couple of years. And so I appreciate that. Thank you. So just a couple things. I believe that vitamin A is really important if you have measles. And so I think if people do face measles, as a family, it might be good for them too to think about a natural health type of a provider, because some of them also know additional things to help, just in that specific scenario. I also wanted to mention, as people are weighing, vaccines or no vaccines, or what do I do? There's a book called The Vaccine Friendly Plan. Dr. Paul's Safe and Effective Approach to Immunity and Health from Pregnancy Through Your Child's Teen Years. And so it gives a really good overview, which I think would be complementary to your sessions. So to help people make those decisions about specific vaccines, and then also what are some, health things that they can do with each of those sicknesses if they do get them, whether they're vaccinated or not. So that's just a really good resource I want to mention. So then when children are excluded, is it for 14 days?
For measles, it's actually 21 days, and that is in line with the incubation period of measles, because it can take up to 21 days for the signs of measles to show up. And again, because it can be contagious for 4 days before the telltale rash shows up, that's when we want to be really vigilant. And again, people might say, well, why, if my kid doesn't have symptoms, why would you keep them out? And again, part of that is so that they can have a close eye kept on them to see if any of those kind of subtle things are starting to develop early. And I'm glad you brought up the vitamin A, because I wanted to mention that that is part of the treatment guidelines in some cases. Unfortunately, we don't have evidence that it helps prevent measles. And we also know that it has to be given under very close supervision, because it can actually cause more problems than it solves. Most of the evidence for vitamin A being effective to prevent measles complications was done in countries where kids were already suffering from malnutrition and vitamin A deficiency. So in those situations, it can be helpful to help prevent complications. But unfortunately, even within this outbreak, we've seen kids admitted to the hospital with liver damage from taking too much vitamin A. So that is definitely something that we would encourage anyone to discuss with their healthcare provider, make sure that they're taking it under supervision, and make sure that it is definitely, again, causing more help than harm, because that's our first goal. First, do no harm.
Absolutely. So then also, so I highly disagree, and this is not with you, but I highly disagree with removing healthy children from school. But again, I know that you're put in that position by MDHHS and the legislature that, that's not something you yourself can change. But for parents, they can talk to their legislatures and ask for that change. And that's something that we need to continue to advocate for, because unfortunately it kind of is a punishment, even though it's not meant to be. But I would ask that, because that is so hard and it's so long, that you be very careful with how broad you make that exclusion. I think there have been cases in the past where our health department, and this was probably a decade ago, where there have been times when it has been very broad, and we've had, 20 kids excluded in Jenison, at one point. So I would just ask that we be really careful with how many kids, you know, if we have a scenario of measles, that we're careful with how we handle it.
And you bring an excellent point. You know, every disease is different. The incubation periods are different. The level of contagion is different. And the level of how much we know about how the disease spreads is different. And I would say even just in my time here at the health department, like I said, I've only been here for about 3.5 years, but even in that short period of time, as we're learning more about diseases and how they're transmitted and how people respond to them, I've actually seen us change some of our protocols in light of that new information. And so again, if it becomes necessary, we target those, we agonize over those decisions because we know that school is so important for kids. And that is one reason why we talk about it ahead of time with the waiver education too, is so that we can say, hey, if this happens, maybe, you know, have a plan for virtual learning, make sure you're getting your homework assignments ahead of time. And we're having those conversations with schools too, to make sure that they're aware that if this were to happen, we want to make sure that kids aren't missing out on the resources that they need.
Thank you.
Commissioner Wendell.
You had said 21 days, is that correct?
Correct.
Now, are they out of school then for fully 21 days?
So they would be away from any shared airspace, yes, for the 21 days.
So I know when our daughter had mono and was out of school, they actually provided a tutor for her when that happened. Is that the case with this for the 21 days?
So that would be something that would be arranged through the school. And that's, again, one of the reasons we're having conversations with the schools is to say, if this happens, and again, it hasn't happened in our county since 1991. So we're all sort of brushing off these protocols and trying to update them with the new information that's become available too. But I think that's a really good point, is preparing ahead of time. And that's the whole point of having this conversation, right? Is so that we can kind of think ahead, what might happen? What are some things we can do to prepare ahead of time? And then hope we never have to use them.
Okay, now with that, the rest of the children are vaccinated then, that are in the classroom.
Right.
What is the chance of them getting measles if they're vaccinated?
This is a really good point, right? Because yeah, it does make it a little tricky. Well, if everybody else is immune, then, you know, why would you keep the non-immune kids out? We know that the 2 doses of the MMR vaccine is 97% effective at preventing measles. That's not 100%, right? So there are cases where someone who has been vaccinated can become infected with measles. And then let's say that person has a 6-month-old sibling at home, and they go home and their 6-month-old sibling gets measles from them, or their grandparents have, you know, they're on chemotherapy from cancer and they don't have a way to fight off the virus if they were to become infected. So again, it can't, pardon my French, it sucks, I know. But unfortunately, these are the things that, as we're thinking about it from the whole community standpoint, we really have to try to make sure that we are really fulfilling our mission to protect health for all. And so those are some of the things that we think about when we're agonizing over these decisions.
Thank you very much. Any other comments, questions? Thank you for your report. Thank you.
Thank you.
Next, we have the Community Action Agency, Jennifer Borowski.
Good morning.
Morning.
Just a couple of updates from OCA. Our Walk for Warmth was the beginning of March. We had a great turnout. We had about 136 people. We didn't quite hit our fundraising goal, unfortunately. Our goal was 20,000 this year, and we made it to just over 12,000. So you'll probably see, if you follow us on social media, some posts going out to try to bring in more donations. Again, the donations aren't just for the event. It's a year-round ask that we have. So there is a donate button on our page, on the Walk for Warmth page. Again, that's year-round, and that always goes toward utility assistance for our neighbors. MDHHS has issued a notice for a grant opportunity for weatherization. So we do have the weatherization assistance program for low-income families. Every 10 years, they put that out for bid. So we are working on that application. It's due at the end of April. And I believe in June is when they'll announce who receives that grant throughout the state of Michigan. Lastly, some exciting news. We are working with Grand PR, Grand Valley's public relations firm, and they are helping us with the rebrand. So you might hear me saying Oka over and over. We're really trying to move toward that name just for simplicity's sake, so that people don't get us confused with Community Action House, and so that they also know that we're part of the county. So we'll have that new name with a new logo. We'll have some social media posts going out. They're going to put together a marketing plan for us. So we're really excited for that rollout. So plan to see something. I believe they're going to give that to us sometime around May. So we're hoping to launch that in the next couple of months. And I just wanted to also share, I know I don't go into a lot of details like stats and dollar amounts and individuals served. Just want to remind all of you and the public that we do have advisory board meetings. So our advisory board is open to the public, and that's really where we get into the nitty-gritty of all the things that we're doing. The financials, the number of individuals served. Again, those meetings are open to the public. It's all on our website. So if there's ever any questions in addition to what I'm presenting here, which is really just a broad overview, we always have that information at our advisory board meetings that are held at the James Street campus, in the building, same building as the health department. And those are every other month. Again, all of the dates are on our website. Any questions?
Comments?
Hi.
Hi.
Thanks for being here.
Yes.
Did you say is that Grand Valley State University that's
Yes.
helping you?
Yep.
Okay. All right. That was my question.
Well, thank you for your report, Ms.
Thank you.
At this time, for time-wise sake, and did you talk to you about that, Jacob, that
Yeah.
you
I
have
support this.
communications on finance from our ARPA partners from Latin Americans United for Progress update. And they have to be out of here after lunch. So if we could, I was going to have Marcia Morales do their business stabilization report.
Good morning. Hello, Board of Commissioners, Finance and Administration Committee. I am Maria Morales, and I am the Senior Director of Workforce Development and Strategic Impact at LAUP. Over 2 years ago, I joined LAUP to develop and lead our workforce development program. Without your consideration and ARPA funding, none of this would have been possible, and I want to extend my heartfelt gratitude. At that early stage, our initiative did not even have a name. Today, I am proud to update you on the progress of Educate, Elevate, LAUP's workforce development program. During the first year, my primary focus was to establish a robust system of policies and procedures that met or exceeded the grant regulations. These included client intake forms, workforce needs assessments, enrollment protocols, and strengthened LAUP's basic adult education programs, and our referral pathways to partnering organizations for career and barrier interventions. We also developed best practices for tracking participant data, reporting progress, defining program commitments, and facilitating data sharing agreements. To further strengthen our employer partnerships, I completed the U.S. Chamber of Commerce Foundation Talent Pipeline Management Training and am now a certified talent pipeline manager, able to create scalable and sustainable talent pipelines. This groundwork led to our initial workforce analysis, which included 6 manufacturing corporations in Ottawa County. Our findings revealed foundational gaps in language skills, leadership development, and digital literacy, needs that were shared across the manufacturing industry. Additionally, we discovered 3 critical insights that guide our current work. Corporations need individualized support, yet most training institutions that we have here in Ottawa County do not offer custom curriculum development. To address this, we now have expanded to 3 full-time staff, with 1, Beatriz Rosales, specifically leading curriculum development for the corporations and partners that we have. Each curriculum is designed to explicitly encompass the skills that each employer and partner in the industry collaboratives that we have are telling us are necessary and critical for the success of their workforce. Number 2, More than 40% of the participants that we've supported in Ottawa County already have bachelor's, master's, or doctoral degrees, but they find themselves working in hospitality, manufacturing, or different industries because they struggle to fully leverage the credentials that they have from a foreign country. At LAUP, we can now confidently affirm ourselves as the leaders in Ottawa County when it comes to guiding these foreign educated individuals through the complex landscape of educational licensing and regulations. Moreover, we are the first organization in the county with the specialized expertise to now be able to support a diverse group of foreign educated and skilled individuals with dealing with the complexity of those educational systems in their foreign countries. And number 3, a significant portion of Ottawa County are under and unemployed individuals. They require foundational skills-based training before even being considered to upscale in their current workforce. Approximately 70% of our participants needed entry-level skills and immediate employment before advancing, impacting our ability to promote to a higher role. So our focus became adopting a build-a-pool approach to broaden the talent pipeline and ensure our participants, including those underserved, can embark on a successful career pathway. Though this approach may take longer to demonstrate measurable outcomes, it delivers immediate benefits to employers and it fosters a pathway to a sustainable workforce in the long term. We are currently on site at 4 manufacturing locations with basic adult education programs, as well as offering resource navigation to remove barriers to employment retention and credential attainment. This year, we also have now launched into the healthcare industry. We've solidified and are now in partnership with Rest Haven to establish a robust talent pipeline. As of Q4 of 2024, with Q1 2025 updates forthcoming in our report, our grant efforts have yielded the following results. These are the metrics and deliverables that we said we would deliver on. We've had 441 participants complete our GED, ESL, or citizenship program out of 600 that we committed to. We've had 302 participants pursue new educations or trainings that we offered out of 300 that we said we would commit to. We've had 481 participants secure employment out of 300 that we said we would do. And we've had 33 participants upscale and enter higher level roles out of 200. Again, as mentioned, priority for our corporate partners, and the biggest thing we identified is the urgency isn't upscaling, it's skilling participants to enter the workforce. And we are over our $1 million wage increase that we said we would commit to. Moreover, we have supported our participants in earning a wide range of credentials and certifications, including CNA, electrician, property maintenance technicians, medical coding, community health workers, blueprint training, QuickBooks, nursing, dental assistants, robotics, and our biggest thing in the past 6 months, CDL licensing and training. As we look to the future, LAUP will continue to deliver personalized career-aligned instruction for high-demand industries. We will strengthen employer retention rates with resource navigation on site and at their corporations, providing steadfast support and eliminating barriers for employees in challenging and unforeseen times. I thank you again for your support. It has been instrumental in helping individuals advance their education, secure stable employment, and achieve meaningful milestones throughout Ottawa County. Any questions?
I'd just like to make a comment. Thank you. I've been to some of LAUP and some of their events, and the work you do in West Michigan is really great. And I'm glad to see our ARPA dollars, how they worked and how they worked out for you. So thanks for your report.
Of course.
Any
Thank you.
questions further on that? Super.
No,
Thank you.
Have a
Thank
great
you
day.
for your wait.
Of course.
At this time, we will have the county administrator search update presented by Double Hall. Are you going to start that out, Gary and Ron?
Be Zach and
Is there-
Mitch from Double Hall.
Mitch is going to, all right.
just nice to walk around a little bit.
Oh, you could have done that before. We're okay with that.
No, I like to sit and listen at least. So I appreciate everybody's time today. I will be as brief as possible, but to go over kind of a few things. First off, to this point, interviews, feedback sessions, conversations have been had with the majority of commissioners, department supervisors, as well as with, I would guess, 50 to 60 staff members. So we got a great response. We got a lot of good information from everybody, which was really helpful. I will point out Commissioner Rhodey was extra helpful with the materials that she provided because that was very helpful in putting the brochure together as we've been moving forward. What we're looking at now, and I'll share this in just a little bit, is the time frame update. So we are on a good time frame still to have a condensed schedule and to get you a qualified candidate, but to be a very thorough process. Our position profile or brochure, I'll share what I'll refer to as a final rough draft with you today. We won't talk too much about content because I know that'll end up going out to all of you at some point here in the near future to get some feedback on. Ultimately, with the goal of getting it published either this weekend or early next week so that we can get that out there. And the other thing is I'm very appreciative of Zach, Karen, Gary, and Ron as I over communicate at times, and Zach responding to text messages or calling me at 9 o'clock at night after a conversation they've had internally has been very helpful to keep those lines of communication open. So if I believe you have the spreadsheet or the document that has the administrator process or will be handed out now, so I can walk through that real briefly, just on a couple of the key points. We can just do the handout for now, yeah. So as that goes around, right now we've got April 11th-ish as the posting date. Again, as soon as we get feedback or additional comments from commissioners, staff on that brochure, and finalize our back-end support with Vitrano Consulting to make sure our application is as thorough and concrete as possible, we'll get that published and out there. We'll leave it open until May 5th, but we start our vetting process probably towards the latter part of April, so that by May 5th, we only have a couple of candidates potentially to do some vetting and interviews with for that first round. May 27th, we are looking at doing the closed session with you all to have a narrowing up of candidates. So at that meeting on May 27th, our goal would be to have a closed session with the board and with selected staff members and narrow up the candidates to between 3 to 5. We'll provide as many candidates as frankly meet the qualifications to you all to consider, and then we will provide our kind of insight as to what we're seeing from all of those candidates, and then allow you all in open session to make a motion to select candidates, say 3, 12, and 33, because we want to keep their information confidential until they accept for in-person interviews. Then, as you see, we're looking at June 4th and 5th to be what I would typically call the interview weekend, but the interview weekdays, that's a Wednesday, Thursday. Wednesday will be focused on kind of and outside the Board of Commissioners and more informal. So they'll have an interview with the Citizens Work Group that has been kind of convened. We will do a tour of the community with department supervisors so they can have some kind of one-on-one time. And then we would have a community open house that evening. Hopefully, knock on wood, it would be before any church service starts on Wednesday evening, as we're looking at 3:30 to 5:30. So if there is an early church service on that Wednesday, I would ask that citizens, board members, or commission members, as well as members of the work group show up early on then on that day. And then on the next morning, we would be looking at your full interviews. So those would be likely an hour and 15 minutes for each one. Again, 3 to 5 candidates. And then we would, you would have a little bit of deliberation or discussion at the end to confirm next steps. But then as you see on June 9th, a special meeting would be called to determine one of two things. Are you going to be needing another round of interviews with a select number of candidates, or is there a comfortability with the candidates that were there and you feel good about one of them? And so I'll look to June 10th, 11th, and 24th as estimated, just based on what that June 9th meeting looks like. Any questions on the time frame aspect?
Any question on the timeline, timeframe? Allison?
May I differ from just the timeline? Is that I just have a question for something else on here. Thanks for all your work you've been doing and for all the conversations that you are having, Mitch, with others. I'm wondering how you are protecting the confidentiality to have the full board selecting which candidates we're going to interview, and how are we actually protecting the confidentiality prior to that?
Okay, so on the application form or the document they submit, they have to submit written request under state statute for that confidentiality. If a candidate doesn't, then theoretically their name can become public at any point in time. However, everything before it gets to the Board of Commissioners stays internal to Double Hall Solutions. So we have a very small team. It'll be myself, April Lynch, and James Vetrano, really that will be the only three that will be reviewing applications from Double Hall's perspective. All three of us have done numerous searches. I think James is well over 50 at this point in time. And so at that point in time, we will provide the three of us with that information. But no other outside person will see those application packets. They will not interview or vet any of those candidates.
So we won't have the opportunity to see all the applicants?
Well, so there's one of two things. We typically do not provide all of the applications to the boards, commissions, councils for two reasons. One is it can bog down the conversation because our early vetting does two things. It's, do these candidates meet the basic qualifications that have been set forth for the job, A, and B, do they have what Ottawa County has said they're looking for? So if they've got experiences that have been noted by each one of you, or if they're missing some of those things, we tend to kind of rank them a little bit, but we can provide all that material to you. That is up to the board if you want to see all of the candidates. In the closed session on the 27th, you will see all of them unredacted, but it is in a closed session, so that material is covered under the OMA exemption. But again, that's up to the board as to whether you want to see all of the candidates or maybe the 25 that we would put forth as, these are the 25 that likely meet what your expectations are. Or what have been set forth by the board.
So if I'm understanding correctly, we as a board will see all the applications in that closed session, but until then, we won't see that we won't see the entire pool.
Correct.
So when we get to that day, because typically there's a lot of information that is included in that. Are you saying that day then we have to decide who we're going to interview? But I'm just saying like that typically takes a lot of really good reflection and a lot of time spent reading through those applications.
You won't get them that day. You will get them in advance. We will send out a closed session packet, or staff will, I should say, that will include that material. But again, it's exempted material for the closed session specifically.
Okay, that's very
Yeah,
helpful.
so you will
Do
have time to
anticipate
review.
How much time you will be able to get that information to us?
That's why we actually had a conversation about this. Our goal would be to have it to you the Friday before, so that you have a weekend, because I believe the 27th is on a Tuesday or Thursday. I can't remember as I stand here, but you would have ample time, I believe, to review those items.
Thank you.
Any other questions?
Perfect.
Very good.
Then if we could run, if you could pull up the brochure profile real quick. I just want to show everybody this. This is what we have so far for the brochure and profile. This doesn't require approval from the board at this point in time. What I'm looking for right now, as I stand here, is really that it looks good and what material that you can see fits with the hopes and dreams of the search. There we go.
Do you have any extra copies of that?
We will as soon as it's out of draft form. So we're getting close to.
Thank you. So as you can see, our goal here, I will do my best. Heyo, look at that. As you can see here, our goal with these, and you'll notice that ours are a little bit different than others. We try to be as pretty picture as possible just because we want to draw people's eyes. So as we're looking at this, as talking with staff, the salary will be 220 to 260 DOQ. Again, that is subject to any contract negotiations that you have at that point in time. We put together an opportunity summary. So this really talks about Ottawa County, what's important, what the values are of the community, and what you're looking for in that position. This will, again, we have examples that we've got to adjust here. I think this is the only one left, but this is really to talk about kind of the key points. You know, if you're in a community, a smaller community, people are looking at walk scores. If there's a realtor in here, they're looking at walk scores, bike scores, medium home values. So this is really to try to, you know, get not just the candidate, but also their families to also look at the position too, because that's an important piece. Regional attractions, we are also looking for help if for those other than Commissioner Zylstra, who represents the city of Holland. We're looking for non-Holland specific regional attractions that are valuable to you or your constituents. Or if Commissioner Zylstra also knows.
Holland has a lot of great attractions, so I can't really be out there, but yeah.
We're looking for a couple other examples. We've got the recreation at the bottom, so we were able to highlight a bunch. But if you have some other really cool attractions that you think would be good for us to include that either you, your family, your constituents have highlighted recently, I'd love a couple more. That'd be a huge deal to add on to this. Yes, please.
I see Tunnel Park there, but I think you could just mention the network of county park systems, everything from the ravines to, good grief, we've got 1, 2, at least 4, maybe 5 county parks on Lake Michigan.
Mm-hmm. Perfect.
Do you have the 2 state parks on there, Grand Haven and Hound? They are the.
Yep.
It's on there? Okay.
Yeah, I believe we've got both of those on there.
Perfect.
And if they're not in that section, I believe they're in one of the other sections about,
Okay.
Yes. Okay, perfect. So yeah, give that some thought as you see this. We like to highlight the history, or for history buffs in here, you know, our friends at Historical Societies really like to key in on this because it's a big part of a community's history. Eventually, the bottom section where we have revenues and expenditures won't just be percentage based, but we'll work with Karen to make it user friendly on the actual dollars, because that's a big deal for candidates. They want to know what is that annual budget look like and where those dollars expended on a regular basis. Yeah. So what you're looking for. So this is after all the conversations, which there is a ton of consistency amongst your answers to the questions that we talked about during those discussions. And so we've got 2 things. What we are looking for is really a summary of all of our conversations. Thankfully, AI does a really good job of overwhelming my brain with how I could write that. And so AI helped me with the top piece, but that ideal skills was taken directly from your language. So we have strategic vision. You've got the operational experience, which was really highlighted by all of you. Communication skills, community connection. Another big piece for a lot of you was to make sure that they are engaged with Ottawa County, that they aren't somebody that maybe, no offense to anybody that lives in Kent County, but they don't necessarily live in Kent County and commute into Ottawa on a daily basis. So this is really where we will highlight what you are looking for and who. This is where they can step in and say, hey, I've got 6 of those skills. I know it. The other ones I can learn, or I will adapt to that as I come into the role. This is about the position, really the job description. So we're going to work with Zach and the staff to build this out a little bit more, only because when we go from what we're looking for to the job description, there's a little bit of a discrepancy between the content and just the amount of information there. So we want to make sure that people understand that the formalized role matches what the idealized role is too. Current and future opportunities and challenges. This was a little bit the Google question that I asked most of you. It was also a little bit about what you see on the horizon for Ottawa County. So we've got a handful of items here under both of those, trying to identify as many of those challenges and opportunities that you all saw and that staff and department supervisors saw too. Community collaborators, these are the folks that the county works with on a regular basis so that people have a good understanding, because you might have somebody that has practical experience in working with one of these groups or many of them, especially if there's someone that's coming locally. At the bottom, top 5 reasons why you want to be the next administrator. We actually, over the 4 or 5 weeks that this will be open, we highlight one of those reasons every week, and we'll do a little write-up to just try to push it out there more and more. Again, I think the top one is one of the coolest things. Ottawa County is still one of the fastest counties growing in the state of Michigan and in the Midwest. And so this is a really incredible opportunity for someone to come in here and to work with you all and staff as to what and how can Ottawa County grow in a productive and sustainable manner. Because the other piece to that, right, is the water issue and water conservation and water resources, which I think half of you mentioned as one of the biggest opportunities and concerns moving forward. Ottawa County economy, this is just highlighting kind of the diversity of it, from agricultural and the kind of farms that are in the area to, I'll just say Hayworth since my wife works there. You've got all of the above in there, plus the technology firms that continue to move into this area. So we want to make sure that people understand it because, again, when you are hiring an administrator or a staff member at this level, more than likely they come in with a spouse or a family. And so we want to make sure that that family or that spouse knows that there are positions and jobs available for them to live, to work at.
Is that the Campbell plant?
Yeah, we were just wondering.
I think it might be. I just looked at it.
I see a big pile of coal.
Should we?
Might want to shift that picture.
After the conversation this morning, I kind of thought maybe leave it in, maybe leave it out, maybe just turn it into a green space. We can do all sorts of things, but yes, I will.
Of course.
Oh, I like that. I'll put American Dunes on there instead, which is I don't know why we didn't highlight it. But yes, I will make sure we remove the power plant. I just caught that. Thank you. Wow.
I'll leave it on there. It's part of our community.
Yeah. So I will say that there are this page, the Ottawa County economy page, and the people and places of Ottawa County are new for us to include because, again, the diversity of this community from just the types of places that you have and the feel of the community is vastly different from north to south and east to west, right? And so this page in particular, I think, can have appeal to all folks that are looking at this community. It highlights your waterfront and the beauty of that. It highlights the rural area where someone can come in and have a small farmstead and make a living, but they can also live right in downtown Holland or Grand Haven and have some of that urban feel. So this is a really neat page that I think is going to highlight all of what Ottawa County offers. And then we get into kind of the basic stuff, the qualifications. We've talked about the master's degree preferred, again, MBA, MPA. We got into that discussion a little bit. If they've got background with government, but they got an MBA ahead of time, it's still pretty good. It still gives them that management kind of degree and education on the back end.
What's that I'm sorry, what is that bullet point about technology needs?
That's a placeholder for us. Some communities will have in contracts that they have where the administrator or the manager will get $250 a month for technology instead of them getting a phone and a laptop.
Still being updated.
Yep.
Okay.
Yep. So yeah, this is just your basic benefit page. And then living in Ottawa County, just talking about the recreational opportunities again, what healthcare, education, all of those sorts of items, and then how to apply. So when we post this and we get this out there, that click here will be a link directly to our back-end software where they'll be able to upload their resume, cover letter, references, and then they'll have a small section that they actually have to type out. For those of you that have had to apply for jobs recently and you had to upload your resume and cover letter and then you still had to fill out a form, our goal is to avoid that as best as possible. So with that, that is where we are at with this document, and I'm happy to answer any questions on this at that point too.
Questions, comments? Mr. Peoples.
Great job. I love it. Couple of thoughts I'm having to emphasize, maybe to think about.
Yep.
I think candidates would like to know our bond rating. There's a dog park at the Ravines that is highly popular. And I think there's statistics about how many people use that. So I think for some people that may be indicative of a community because it's really popular. The third issue that I did ask you to think about is the percent of our community that's connected to broadband. I think that sends a message too. And those are the three thoughts I had, but otherwise I love it.
And I could talk with Paul Sachs about the broadband piece, because I'd hate to rely on the FCC's maps to tell me anything more than you have 25 megabytes here. Well, that's not really true, is it? So yeah, we can absolutely add those few things. And not only does dog park, attendance indicative of a community, but also, frankly, it's accepting of canines and pets, which frankly, not all communities are. So I think that's a big deal here too. Any other initial comments on this that I can
I thought it was
address?
very visually appealing. Will we have an opportunity to see to be able to give more feedback and so that we can actually read what was in it? Because we quickly went through it. I would love an opportunity to read through it and then provide feedback.
Yes, so I received this draft about 8:40 this morning, and I don't want to pass along anything without it being finished. You were all very busy. So as soon as we get the final version, that will go out to all of you.
Great. Thank you. So what's your time frame of us needing to give you feedback?
I love the term as soon as possible in this circumstance. But if I put a deadline, assuming that we can, this is fairly final, we'll make sure that staff have had a chance to review it as well to make sure from their perspective it's all good. We pull out some of those placeholders. If you can get it, or if they can hand it out or get it out to you all by Friday, if Monday is fair, I think if we can get it back Monday and then we can get it posted on Monday, it's a 3-day delay over where we were originally hoping, but it won't make or break any sort of situation. So if that's fair for Monday, it's a 48-hour return. And that's typically what we've done, is about 48 to longer.
Sounds great.
Okay.
Any other comments, questions? Super.
Thank you all for your time. I truly appreciate it. It's been a fun experience, and it's just going to get more fun. We have had a number of conversations with potential candidates, so that is really, exciting as well for us. So thank you all, and have a great rest of your Thursday.
Thank you.
Thank you.
This is a second chance for public comment. Is there any other public comment today?
Sheila Detloff, Holland Township. I just have a few reactions to some of the things that Commissioner Rohde brought up during the discussion about the county logo. She said, "You are making assumptions about the cognition of our citizens that is wrong." I would argue that that is apparently not true, given the emails that Commissioner Teeples cited that he received. If I were approached by someone with a sheriff's deputy badge on, I would assume they're speaking to me with the authority of the sheriff's department. If I got a letter from somebody with the Consumers Energy logo on it, I would assume they're speaking to me with the authority of Consumers Energy. And if I got a letter from Ottawa County with the Ottawa County logo on it, I would assume, as a reasonable person, that they are speaking to me with the authority of the county. The analogy about Bill Huizinga, Rule 3.1 for this board states, the authority of the board is a collective one. If you can show me a similar rule for the US Congress, then I'll concede that analogy. Third, Commissioner Rohde pointed out that commissioners have the option of using the logo on county email. So my question is, why not just email the president of GVSU? The letterhead that was sent on was specifically created to look like letterhead coming from county commissioners with the county logo. As Commissioner Jurisma pointed out, he didn't realize that you had letterhead. That's because You don't really, you have to create it. You take the template and you put your own personalization on it. So there was a concerted effort to make it look like this was communication coming from the county, not just from yourself. And finally, I'd like to know when governing became winner take all. Commissioner Rohde said, "You do not know my constituents." And she said, when you're elected to represent people, you should use your voice. I'd like to point out two things. One is that Donald Trump lost in the 2 precincts that GVSU is in, and Commissioner Rohde herself lost by 34 points in the 2 precincts that GVSU is in. So perhaps you need to take into account all of your constituents, not just the ones who voted for you. And since I have a few seconds left, I just want to point out one other thing. Commissioner Bonema was removed from a committee and perhaps censured, I can't remember if you were censured or not too, for what was stated as abuse of power for filing a complaint with HR, which he was entitled to do. I would say that that makes abuse of power a really, really low bar, really low. And if using the county logo to appear as acting under the authority of the county doesn't also fall under that, there's some cognitive dissonance there.
Thank you. Any other comments at this time?
Karen Obitz, Spring Lake. By the end of the discussion about agenda item 5 today, the one about the use of the county logo, there did seem to be some consensus over an acknowledgement that what had caught the attention of Ottawa County residents once those letters were made public via social media posts had much to do indeed with the content of those letters. As several commissioners noted, use of the county logo for individual commissioner communications might well be legitimate, so long as there are clear guidelines in place defining what constitutes appropriate use for individual commissioner communications versus board as a whole communications, as in resolutions, by way of example. In other words, it seems there was agreement that the content of individual commissioner communications using the county logo matters. So with that in mind, I'd like to offer this overarching framework for consideration of what those guidelines might take into account. I personally believe issues related to state-mandated commissioner, board of commissioner responsibilities are qualitatively different from issues that are not related to what it is as elected commissioners your job is. So while I can't speak for other residents who reached out to board members to voice their own concerns about the content of those letters to GVSU, my concern was due to the fact that I didn't judge the issues they were addressing in those letters to be congruent with the role of a commissioner, whether stated as an individual assessment of the situation in the university or as purporting to be representative of the board. In other words, I didn't see it as the lane that commissioners or a board as a whole should occupy over against what was stated in those letters about their disagreement with GVSU policy. So that would be my suggestion, that in any future consideration over guidelines that there'd be an acknowledgement at least that sense of what it is that I felt went awry in terms of those letters. Thank you.
Thank you.
My name is Dave Barnowski and I vote in Port Sheldon Township. I wanted to call out the Moss derangement syndrome and point out that it's the abuser's way of switching roles with the victim. If there was anybody who was using controlling methods, it was the leadership of this board in the last 2 years. So if you've got complaints about that, Ms. Rodea, then you should look back to your past and see how it was done. And I wonder if they might be if he would have been using that logo so much if you'd change it back to what it used to be, which is what I'd like to see, where you belong. They changed it without any effort, without any thought. That previous logo they put a lot of effort into choosing that logo, where you belong. I'd like to see that brought back. That research, there was a lot of research done to bring that logo, that saying about, I'd like to bring that one back.
Thank you. Any other public comment at this time? Seeing none, we are adjourned.